in the
however, to afford another opportunity to the petitioner to appear, the matter stand at 1:30 as a last chance to release the matter on social.
আজকে কত তারিখ? 5 তারিখ।
Sure.
সামনে 11 তারিখ রেখে
On 11th yes. The Association Advocate the appellant is directed to communicate this order to the Learned Advocate to enter appearance on behalf of the petitioner respondent.
Thank you.
এটা তো অ্যাপিলই হবে, আমি ঠিকই বলেছি।
হ্যাঁ,
ওটা অ্যাপিলই হবে, আমি ভুল করেছি, সাহেব ঠিকই বলেছে, এটা তো এমএটি। Give a written notice to Mr.
Yes.
And if then we will dispose it upon that. 1 week will be, sir.
Yes.
Password document.
The habitual defaulter, the Borga matters. Till date almost কত amount কত?
More than 5 lakhs.
Last occasion, Your Lordship,
More
directed
than-
to file affidavit in reply.
Yes, this is the
I have received.
reply.
You are appearing for
Respondent number 4, private
Borgadar.
respondent.
reply you have just now filed. Have you
No,
given-
reply I have filed.
I have
Oh,
filed
you
already
have
opposition. Already I have filed.
22nd January.
They have
Hmm.
filed reply.
Dear Lord, are you reply is not be recorded character.
today it has been served upon you or?
No.
No,
22nd.
22nd January.
Already served. Already served, Lordship, before that.
And my lord needs to fix this matter, my lord, because it requires
It has strongly kept on record. This the matter for further consideration. The mentioned আছে তো একটা ডেট ফিক্স করে দাও
Okay.
under the heading app.
Immediate reply filed on behalf of the.
না, দুটোই করেছে বোধহয় না? অপোজিশনটা ইউ হ্যাভ আর্লিয়ার ফাইল। অপোজিশনটা কোথায়?
my lord, they have served opposition, my lord. I don't know whether
I have already.
Opposition আছে।
ও ঠিক আছে।
আচ্ছা জজ সাহেব পেয়েছেন
Station. Gotcha. Is the matter for hearing. For further hearing on
17 তারিখ করলাম।
now, as the matter is now ready for is the matter for final hearing on 17th.
my lord.
Yeah, 15 or 17th.
My lord. 7th.
In March.
17th, 1/7.
My lord.
1/7.
17th. I'm sorry. 17th. 17 তারিখ। My lord, item number 3, my lord. I am for the appellant. My lord, what has happened, my lord, in this matter? The learned single bench has passed an order by directing the concerned DLLRO. My lord, before I
Restoration
proceed, my
allow.
lord, kindly allow
No,
restoration.
Lordship, the restoration needs to be filed along with the section 5.
My lord, my prayer is there. I have,
May kindly seize the
I
cut
have,
It's a 2014 order.
আমি বলেনি নাকি আমার restorationটা?
আমি একটু ল পয়েন্টটা বলে দিই।
Prayer portion, my lord,
Order
kindly
9.
come.
Order 9 rule 4টাও তো আছে।
I can, my lord, file restoration application along with condonation, that is at kindly come to the prayer portion. To condone the delay of 371 days caused in filing this instant application for restoration. All I need to require to pay court fee. 2 court fees has to be paid. Here, state is the party, so I was exempted. State is the appellant, so I was exempted on both the counts.
Why didn't you appear?
I missed it. I was on my legs.
Your DM was not on legs. What explanation of delay you have given?
Kindly come to
Seriously,
para
opposing-
5.
Lordship, I'm
seriously.
Lordship, if this is allowed today, then from the next onwards, all might be allowed to file this kind of restoration without a section 5. If this is allowed today.
Oh, there
Plenary
is a
power.
judgment of Justice Indira Banerjee on
Lordship,
and there is a judgment of Supreme Court also.
Lordship,
Separate section 5 application is not required.
Lordship,
It is
Lordship,
just technically.
Lordship,
If
Lordship.
the pair is made, then it should not.
Lordship, that will be my first ground for
Yes,
opposing.
yes, that-
And the
that
second will
so-
be
So, technical approach,
Lordship, Lordship, Lordship,
insisting them to count
Lordship, Lordship,
another,
Lordship.
should be.
And Lordship, it is also with regard to
You
the
want to use opposition then?
Lordship, Lordship.
Difficulties, they are running, they have filed contempt application. Today it is appearing. Last 4 weeks, since my learned junior has mentioned this matter and department could not trace the application, it could not be placed before my lords. Now department has found out this restoration
What was-
application. Side by side, they are pressing hard in the contempt proceedings.
What was the order passed?
Lordship.
Order passed is, kindly come
Lordship,
to the impugned
May I
order, I'll
indicate?
show.
7th March
DM
2014.
Arey bhai, ki mushkil.
Lordship, now in the contempt application, the time sought for every time by the state was to file an opposition, file a report.
So, madam, don't do anything for 1 week. We shall hear it out and
Lordship, if that is the
Contempt-
Lordship kindly hears it, I'll not use an opposition.
we shall hear.
Lordship, then hear it today. Lordship, now the matter is listed today. And today is the date for final consideration. Lordship may kindly considers the prayer which is being made. Lordship, it's a 2014 order directing that the DM along with the
So, why you are insisting, madam, that today itself it needs to be heard? They have used an application. You give your opposition. We will keep it at an application within within a week.
Lordship, I am not opposing.
Then
Lordship, what my humble prayer is that
we shall
today
fix
we
the-
are on restoration. The
Right,
main
right.
appeal, he has not obtained a stay. So in that event, your Lordship, I am not precluded from moving my contempt application. Then
Was
all
his prayer for stay refused?
Lordship, it is a restoration.
No. Earlier, was his prayer was there any?
They
interim
could
order?
not move. The matter, the appeal was filed in 2014.
I have all the orders
For
in
default
my lord's
2020.
file. My lord can see there was a stay order for a substantial period.
Lordship, the urgency is that today, because I am moving the contempt, so the urgency arose with regard to restoration.
Don't mislead
14
the
order.
court.
2020 dismissed for default, 2021 one restoration, moving in the year 2025. This is the conduct. Your Lordship may kindly records that. I am not in a hurry. Lordship, it is the conduct of the state. Then the state will be in a habit of
We are not staying the proceedings. There
Lordship.
was a stay
Lordship.
that has gone.
Lordship, it is gone.
We are in scene of the matter. The contempt, if it is appearing today, you pray for an adjournment. We will dispose it of within a week.
Lordship.
What is your problem?
As your Lordship desires, then I'll have to.
We need not go into that issue. When you are opposing this application, use your opposition within a party. We shall fix the matter, and till such time you don't proceed with the contempt proceeding.
Lordship, as your Lordship pleases.
There was an earlier stay. Is it? No. They don't do such. হয়েছে ডিসমিস 3 বছর 1 বছর পরে এসে
contempt application,
371
contempt application এই করছে। আর move করছে
কোনো ইন্টারেস্ট ছিল
অপোজিশন
conduct of the state is not.
just because the contempt now filed, you are pressing for an
Yes.
issue. You cannot sleep over the issue.
2-3 occasions when the other division bench has the determination, we tried to find out the restoration application. Department could not get the restoration application.
Mr. Dhar,
Thereafter,
whatever it is, it was filed belatedly.
yes,
This delay was on the part of the DM. Why say they shall unnecessarily wait for hearing of the appeal when everything has gone? Your conduct is also not proper. Anyway, she will use an opposition. We will decide it whether we will
Yes.
restore or not,
yes,
or we can take it up and ask.
Yes.
We cannot.
Most learned advocate press for leave to file affidavit in opposition to the
Application being can for.
to the application being can 4 of 2021. The prayer is considered and allowed, lest such affidavit in opposition be filed within
Lordship, in 3 days. I'll serve a copy by Friday.
3 days.
Within-
Reply
reply within a week.
Lordship, then let me be allowed to move the contempt application. Lordship, what had fallen from your Lordship is only granting 1 week's time. I can use the opposition in 2 days.
We have not fixed the date.
Lordship,
আজকে কত তারিখ?
today we are on 4th.
On with a copy to করে দেও।
with a copy to
within
Mr. Dhar with a copy to now
Amritlal Chatterjee, my lord.
Mr. Chatterjee, advocate on the court on behalf of the applicant.
reply there to within 10th করে দাও 11 তারিখে।
আচ্ছা, reply there to if any be filed
করে দিস
within 10th March, is the matter for further consideration or delay
Under the same heading.
under the same
কবে দিল?
11th, come on 11th.
Lordship, Lordship.
Dispose undertakes that she
কেন?
will not proceed with the matter.
আরে মার্চের 10
আচ্ছা,
তারিখ ফাইল করতে বলছে 11 তারিখ তো মামলাটা আসবে।
proceed with the contempt in the meantime.
Lordship, then accordingly I shall be placing that before the Honorable Court,
No,
taking
we
up the
are-
contempt.
we are-
11th.
We are recording that you have undertaken not to proceed in the meeting.
Lordship, till 11th. Lordship,
I'm deeply
grateful, my.
Item number 4, I am for the petitioner challenging the non-granting of injunction order. I have come before this court. Till now, my predicament is service could not be completed because of the fact the server is down. The postal services server is down. We cannot see the whether it's been served, reached or not.
Mr. Ganguly, you are for?
For respondent number 7, 11 to 20,
Huh?
22, 29,
7 to
7, 11 to 20,
7, 11,
20,
yes,
11.
7, 11 to 20.
22, 29,
7,
30,
11
31,
to
37, 38, 43 with
20.
my learned friend.
43.
I am appearing on behalf of the respondent number 6 A and B, 39, 44, 45, 46, 48.
Then who are left out?
Who are left out?
I don't know.
No,
But,
you don't know whether you have not. Only tell them
45, 46, sir. Apni
আমি
45,
45,
Where is your
44,
junior?
45, 46,
48,
47.
47
আপনি নেই
Who is
স্যার
for the
আপনি
state?
47 এ নেই
Say,
appearing on behalf
48 আপনি
you are for
দাদা
state. Very
48
good.
আপনি 47 is missing 47, nobody is appearing. I can see, my lord.
You 6A,
6A, B.
6A, 6B.
And 3A, 3B বললো।
B.
26.
You said 3A, 3B,
No, no.
6A.
আপনি 6A, 6B আরেকবার বলুন না।
6A, 6B, 39, 44, 45, 46, 48.
Yes.
And Mr. Ganguly 7, 11 to 20, 22, 29, 30, 31, 37, 38, 43.
আচ্ছা
তাহলে
21,
বাকি
20,
কে রইল? আর এটা তো বসে
মানে
দেখতে হয়।
20, no, 37 is left out and
37 Mr. Ganguly যায়।
no,
হ্যাঁ,
37 and appearing,
oh,
38.
আচ্ছা। আর
তো Mr. Ganguly, can we
21
hear?
কে?
There are, we can hear it or
23 থেকে
Matter is fixed on 21st April.
21st April.
21st April. They are paying for interim order. And with the preemption case, they purchased during the period, preemption was pending and it subsequently decided in my favor. So therefore, it will be in my respectful submission, it is for the tribunal, right, the honorable tribunal to decide on 21st April what happens. Subject to what your lordships consider.
মানে
সার্ভিসটাই তো কমপ্লিট হয়নি।
মানে 21
So you, Mr. Dhar, you complete service upon the remaining and come back.
my lord, my lord. My junior has taken note, but still my lord, 21, 23, sir একবার দেখুন না স্যার, 21, 23, yes, 23 দাদা আপনি আনুন তো, 20, 24, 25, 26, 27, 28.
It was pointed out
Oh.
that the service some of
Acha.
the
27 and 8, Dada.
Mr. Dhar pays for extension of time to complete service. In view thereof, this is the matter for further consideration on
20th March করে দাও।
20th March.
মানে
21st March, there, 20th March, if you can complete.
No, it is the 29th April.
We know that. He will make a prayer for interim order.
Yes, my
We
lord.
shall
Or
consider.
instead of 20th March, 21st
যাচ্ছি
March, or 28th, I shall not be here.
ও তাহলে 24 তারিখ রেখে দাও।
24th March,
it would go again close to my next date.
তাহলে 20 তারিখ
29th
করে দাও।
April, this.
20 তারিখ
No,
করে দাও।
29th April. That is April 29th.
We are March. That's of March.
ওনাদের লিখে দেবে।
Kindly my lord, record my lord, in respect of which respondents they are appearing, at least,
হ্যাঁ,
my lord, that would help me.
সেটা কস্ট টাইটেলে মিস্টার গাঙ্গুলির ওইগুলো দিয়ে দেবে আর ওনারটা এতগুলি দেবে।
স্যার সেটা আমার দেখতে সুবিধা হবে, আমি তাহলে বাকিদেরকে সার্ভিস করতে পারবো।
Did I appear for the petition?
This matter, my lord, I am appealing for the
Lord,
respondent number 5 and 6.
the Borgada. Lord, the petitioner is a recorded Borgada.
7, 8, 9.
Aviator service.
সার্ভিস আপন অল
Yes, yes, yes. Yes, I am filing aviator service. Lord, the petitioner is a recorded Borgada. He used to cultivate the land of a widow, Shanti Lata Singh, and she expired in 1978. And up till that period, my lord, we have gave her the share of the produce as per law. And after his demise, one Topon Kumar Bose,
she expired on
1978. This is very vital. And after her death, my lord,
no sir, please tell us which order you are challenging.
last page,
We can read that order and then
yes,
hear
yes,
it.
yes.
Page, my lord, it starts from order sheet, last order sheet, on 3rd October
3rd October.
2023. Last order.
Kumar Banta ki likhche, seed of
3rd October 23 order.
Yes, ma'am. My learned friend has challenged.
time but right now.
After 2 years.
আরে সেটা তো পরে।
You are the recorded tenant.
Yes, I am the recorded Borgadar man.
No,
Huh?
no, you are the recorded
You are
Borgata.
not the Borgadar.
No, no, Borgata is, I am the petitioner is the Borgata.
Krishnapodo,
Krishnapada, I have the certificate, I have annexed.
So you have been asked to pay the remaining amount to the tenant.
Lord, I shall tell the facts, my lord. Lord, very short facts, but very important facts.
contempt application has filed.
They
They
have
have not
also filed
annexed
a
this
contempt
order.
application.
They have handed over the order.
Contempt application is my
Pending. I have handed over the certificate copy of the order. They have not annexed. My landlord friend has.
আরে দাঁড়ান না, ওই যে যাবো তো আমি ফ্যাক্ট
4th of March, it is, today is the date.
I shall highlight some facts.
No,
Lordship, kindly
you
hear.
have admitted.
Admitted, my lord.
Said
Yes,
that
that
it
is
is
admitted.
But Lord, the ownership is in dispute. The
What?
ownership is in dispute.
That is the
Lord, after-
another issue. That is after.
If the ownership is in problem, you are not paying on your own. You are paying as per direction of the tribunal.
Yes.
But Lord, that is the whole problem.
So
But,
that
Lord,
payment
two-
will be subject, that
But-
payment will be cannot be a bad payment. It was in terms of the tribunal's order.
Lord, my submission would be before your lordship, my lord, let the last installment to be deposited be kept with the BLRO. Because, my lord, 6, 7, 8, and 9, they are also claiming as the ownership.
To go and tell that to the tribunal.
The tribunal, and nothing remains now in tribunal. Contempt application has been
Yes,
filed.
so to go and tell it in one
Two installments we have already paid under compelling circumstances because they said that your burghership will be extracted. Lord, what is the
place your case? What do you
Lord,
want?
lordship kindly
Kindly
hear me
see
for
the-
5 minutes, then your lordship kindly decide.
My landlord friends are.
Let him finish. We will
Yes, yes,
hear.
ma'am.
Yes.
Sorry.
Lord, one Shantilata Singho, he was the original landlady of the entire land which I used to cultivate under her.
Hmm.
And that lady expired in 1978. And after her demise, my lord, one Topon Kumar Bose, he claimed that he is the owner of that land and we used to pay the share of the produce to him. And after, my lord, the demise of Shet Topon Kumar Bose, we used to deposit the share of the produce to his legal heirs, who are the respondent number 7, 8, and 9 herein. And till 2017, we deposited the share of crops to them. Now, my lord, the respondent number 6, he is the secretary of a newly established committee, that is Shantilata Singho Memorial Committee, by the respondent number 7, and that is the respondent number 6. That committee is respondent number 6.
Where is the committee?
Lordship,
Where is the committee implemented?
on the basis of an Orpon Nama, they said that the ownership has been devolved upon that respondent number 6. Upon respondent number 6.
6, that is Sudhin Kumar Basu.
Sudhin Kumar Basu is respondent number 6, and respondent number 5 is the committee.
Respondent number 5 is the committee.
Shantilata Singho Memorial Committee. But what is our submission? That Orpon Nama, that was absolutely, whatever it is not a genuine one, it is fake. Anyway, that name has been recorded and that committee has also recorded its name as the recorded owner.
Committee is the recorded.
As they have mutated their names. So but till 2017, my lord, we have deposited the shares to the heirs of that Shet Tapan Kumar Bose, who are the 7, 8, and 9, the respondents hearing.
Where is this proceeding order of 17th August 2018?
আছে কোথায় বলুন দেখুন that Orpon Nama we have annexed.
Proceedings is
17th August 2018 order.
17th August.
starts from
Prescribed authority order of 17th August. Where is that?
Page 56, my lord, page 56.
Page 56.
50, 51.
56 is tribunal order.
My lord, I put that 51.
Unisher mal.
My lord, kindly see page 50, my lord.
My lord,
kindly
page
see
50 and
page
51.
50, page
Sorry, my lord, sorry.
57.
Page 50, page 50, annexure P7.
Bhakcha's office.
This was in 18-1 proceeding.
Yes. Yes. And my lord, from the very beginning, we are opposing.
Represented by
We are objecting.
the owner of this is having applications to.
The issue has been determined by the PLL error.
Yes, my lord, that is true. But my lord, how the land
18-2, it is of the PLL to decide to whom you will pay. Who will produce
That-
deliver the share of.
but actually, my lord, what
That has been determined.
my
that
clients
issue-
wants, my lord,
issue
that
has
we
no
want to
longer-
pay the right owner.
You
Sir,
have not
please,
challenged this.
this order has not.
Yes, that was challenged.
This order you have not challenged. This order, on the contrary, you told the tribunal that you have complied with that order. Kindly come to your order of 3rd October 2023.
Yeah, you prepared appeal under section 19.
Yes, yes.
That has been rejected.
Yes, that time.
So,
Yeah,
the issue has been settled.
But under compelling circumstances, we have paid
sir,
out of the
you-
2 installments.
no, we understand you, but your challenge, that challenge has already attained finality. And in the 3rd October 2023 order, you yourself said that I will comply with that order, give me some time.
My submission, that was under compelling circumstances. Otherwise, my Borgadarship, they threatened me that will be extended.
Naturally, because you lost in the statutory appeal. A statutory appeal you lost in 2019. Thereafter, you challenged the same before the
My
judge.
submission is this: how the land of a lady, a Hindu widow, can, by way of an orpondama, can be transferred to a committee.
Why not? Orphanama, he has.
But the person, the respondent number 6, how he became the owner? Otherwise, if you don't have the ownership, how can you make the orpondama in favor of another person?
Can you got any locus to challenge the Orphanama?
যাকে shoot file করুন দিয়ে।
Civil suit is the appropriate court. If so advised by
I have said my 7, 8 and 9 as the party. They are also present. They are also present, I understand. But I do not know whether any civil suit has
So
been
they are
conducted.
fighting amongst them. You are against him.
No.
I am 7, 8 and 9.
Huh.
So we are also the owner because Shantiral Singh was the original recorded owner, that issueless. And the orphanama which has been created behind our back.
Good.
We came to learn that fact. Therefore, we have already.
So did you appear in the, you have challenged the Orphanama?
We have taken steps for that.
You challenged. What
Challenge
step?
did come.
My Lordship kindly, Lordship kindly see the prayers.
Only my mutation, cancellation of mutation.
Which prayer?
Yeah, that is page
Mutation.
It starts from page 23. Yeah. Lordship kindly go through the prayers. For my
Page 23.
and onwards. My Lord,
Yes, for your satisfaction.
for my satisfaction. For my satisfaction. Lordship kindly go through.
23.
23.
Yes.
What you have stated.
Writ of mandamus, my lord, recommending the response.
23.
Another mutation,
Immediate investigation by the competent authority.
Lordship kindly go through it. Then whatever whatever your Lordship will pass the order, we shall be bow down to you.
Lordship may be permitted to file short affidavit in this.
Affidavit can.
It is not the forum to raise this issue.
Yes.
Mutation challenge করলো না original application. Rite এসে।
My Lord, we have also prayed for a stay of the
Orphanama executed, then you are.
stay of the contempt proceedings. My Lord, since there is a delay, contempt proceedings is going on. Lordship kindly at least stay that proceedings. So, but
Filed and undertaken disposed of, my lord, I have handed over to your lordship
Entertaining
the order. Because they have not undertaken. The owners, we are in
Or
difficult.
you can withdraw. Choice is yours. We have said that we are.
Withdraw করে না। The contempt application cannot be stayed because we
cannot-
have
we
already
cannot-
deposited 2 installments.
Sir, we have expressed our opinion. At this stage now, you will decide.
Withdraw করে।
And if you, why do you?
The lordship and they are withdrawing that application. And my lord, and lordship liberty to apply before the appropriate authority.
Yes,
whatever.
appropriate forum,
Lordship, kindly-
Yeah, that is always liberty. Have every right.
On behalf of the petitioner.
May I take back or may I, my lord, deposit that order sheet? The lordship, as your wish, ma'am.
My lord, lordship kindly, lordship kindly record one sentence, my lord. Liberty is to take
No, no,
any
that
other state.
liberty you all.
It has already.
Yes, next.
Always with you.
As you lordship.
Six.
Item number 6, Lordship, I'm led by Mr. Arindam Banerjee, Lordship, is on legs. Lordship may give a short passover, my lord.
Not password, it will be there on Tuesday. Yes, next.
Lordship, in that case, my lord, may I start?
No, no, Tuesday. Yes, next.
I appear for the lead
Appellant.
petitioner appellant.
Your service complete.
Well, my advocate on record, I don't find him. I am sorry.
Tuesday. Yes, next.
But I'm so sorry, my lord. I apologize for him.
8. Yes.
Lordship, please kindly give a short passover, Lordship.
What are these 2 applications? Can 1 and can 2?
Lordship, I don't have further instruction about this matter, Lordship. My senior
Then
is.
why did you mention for inclusion? এগুলো কি returnable ছিল? কি করবো? Not today. Not today.
My lord, in this matter, I am applying for the private respondents, my lord, 1, 2, and 3, my lord. And my lord, in this matter, is a patrick case, my lord. The petitioner was directed to be absorbed in the post, my lord. All are
Who
58
is
years
your
old.
other side?
All are 8 years old, my lord. That is why I am.
Huh?
All are 58 years old. Only 2 or 3 years they will serve, my lord. They are, my lord, preparing again one after appeal against the order, my lord. My panel was prepared, my lord. That was not subsequent advertisement published. That was challenged. That was, my lord, cancelled by the single judge.
তো appear করেছিল তো? First time.
No, no, my lord. It was taken up for hearing on 6th March, 6th, my lord.
Who appeared on behalf of the state?
My lord, Mr. Sen, my lord, appeared.
Mr.
Sen, Amol Sen, my lord.
Amol Sen. You have filed contempt.
Yes, my lord. That is fixed, my lord. On several times adjournment was granted, and 7th, my lord, this is fixed, my lord.
There is a 75 days delay.
If delay, my lord, I'm nothing. I have nothing to say, my lord. Let the delay be counted. My lord, that was not also. There was also ground, my lord. But I am not opposing that prayer, my lord.
Like in next week, মঙ্গলবার
11 তারিখ অনেক হয়ে যাচ্ছে। একটা বল
10 তারিখ
আচ্ছা
অর্ডার করে no one appears though.
None appears on behalf of the appellant, nor has any accommodation been sought for. So Mr. Satasal and the advocate requesting the respondents are present. Is present. We are of the view that presence of the aware of the Ashish scheme that to appear release the matter for further consideration on 12 March. The respondents are requested.
না দরকার আসছেন তো ও তো রেসপন্ডেন্ট স্টেট আসছেন
On 12th, we are keeping it.
we have kept it on 12th. If they do not appear, remind us, we will take up the matter.
Yes, my lord. Yes.
It's the first time it has appeared. Yes, next.
My lord, I appear for the appellant, my lord. My lord, may I file affidavit in reply in respect of Section 5 Limitation Act, my lord?
Chip, I'm for the and by Mr. Mitra. File affidavit in opposition.
Even 7,999 days.
Now, I can delay of 23 years.
My lord, kindly have a look at the notification, my lord.
My lordship, a date
My lord-
can be fixed for here.
My lord, the notification, according to this notification, my lord, notarized affidavits are not allowed. This is the order by Honorable Chief Justice, my lord. I have annexed it.
No, when was the order passed? Order was of
No, their notarized affidavit in opposition. It should not be allowed, my lord, due to technical reason. Because of the fact that notarized affidavits are not allowed.
Acha, you tell us what is the matter.
My lord, that matter is that, my lord.
So first you have to place your section 5.
My lord.
Place your section 5. What is your explanation of the delay?
My lord, explanation has been in nutshell described in affidavit in reply as well. It is
You show us your pleadings in the section 5.
yes, my lord. Kindly have a look.
Just a moment.
Paragraph 4, 5, and 6.
Yeah. 23 years. Your lordship,
Paragraph 4.
4, 5,
date
and 6.
can be fixed for hearing next week, your lordship.
Where is Mr. Mitro?
My lord, Mr. Mitra is appearing, my lord, in on behalf of the Union of India, my lord. My lord, he come, my lord, today. It's any date, my lord, next week.
So you file agreement opposition?
Yes, yeah.
Today you file reply.
Reply, yes.
The affidavit accepted by the parties are taken on record. So, as the matter, as the application for confirmation of delay is ready for hearing, list the matter for further consideration. List the matter, list the application for further consideration on
ওই যেটা দিলে ডেটটা কই বারো তারিখ কি করে 12th
Much obliged.
application কত
ছোটা ডেট বললো 10-15 11 এরপরে পাম
এটাতে মেইনটেনেবিলিটি
Today I am supposed to satisfy your lordships on the point of jurisdiction of this one.
Oh.
Because this is the last point that was raised during my argument, my lord. And my lords were talking about a judgment delivered by Delhi High Court. One judgment I have found, my lord.
You have not taken the maintainability point, Mr. Nondi.
No, I have not said anything regarding this.
We were asking to satisfy on that reason. Anyway, you come to the merit. What is the matter? Tell
Merit.
us.
My lord,
Maintainable.
খাতা একটা ছিল একটা খাতা ওটার মধ্যে সব নোট করা আছে
না, তুমি দেখতে চাইলে দেখতে পারো।
I got suspended on 4th September 2024. I got my charge sheet, my lord.
Yeah.
সব নোট করা আছে জাজমেন্ট
Which one you would be placing the stay application? No? Your annexures are in the stay application.
Stay application and my lord, subsequently, since I have not filed the writ petition in the stay application, my lord, I have affirmed supplementary affidavit annexing the writ petition as well as the supplementary affidavit that was filed before the single bench. So all my documents are with these two documents.
So kindly take us to the order first.
My
Which
lord.
order you are challenging?
Order passed, my lord, by the single bench. Kindly takes the memo, order dated 16th December 2024. At the time of, my lord,
So writ petition was dismissed. Or,
at the first date,
Achha,
on
give us,
first date,
or give us 2 minutes, 3 minutes time.
my lord. Suspension order is at page 59B of my stay application.
আমাদের যে নোটটা জমা দিয়েছি কোথায় সেটা জমা দিলাম এটা কোথায়? সাপ্লিমেন্টারি ওয়েট ফাইন, থ্যাংক ইউ।
Kindly text, my lord, page
Have you
59.
brought the judgment to Joyraj Bhai?
No, my lord, I have not brought that judgment, but my lord, that is settled that courts must be cautious while dealing with disciplinary proceedings and suspension. That is settled. Now, my point is something else
Paragraph 18 was the basis of this order.
of this order.
You haven't brought that judgment.
No, my lord, I have not brought. Possibly my learned friend has brought it.
জাজমেন্ট 2000 কোনটা বলেছে?
Now,
2000
what happened
Thousand-
during the pendency of the writ petition, my lord?
We have got it. You have got it.
relying of the judgment of the trial court, my lord.
No, no, Jayanti Bhai.
Yes,
Supreme Court order.
yes, দেখছি,
এটা তো তোমার ব্যাক পেজের ব্যাপারে।
দাও দিচ্ছি ওনাকে একটা দিয়ে দেবো তো, অফিস কপিটা নেই।
জয়ন্তী ভাই, ওটা জয়রাজ ছিল।
Joyraj.
And another judgment, my lord, Union of India versus Ashok Kumar Agrawal. Yes, I have got that. বার করতে অশোক কুমার আগরওয়াল এখানে আছে। এই দাও এটা না।
একটা কপি।
এটা নিয়ে নিন, একটা তো এটা আছে, দিচ্ছি 1 সেকেন্ড, এটা দিন। এই যে আছে, একটা দিতে হবে, এটা বার করতে হবে।
Yes, where is your order of suspension?
Page 59B of my stay application.
Suspension.
In fact, this judgment goes in my favor.
Civil service. ও ধরেই নিচ্ছে যে it is a civil post. বুঝতে পারছি না স্যার, কিন্তু civil service এর not under challenging সেটা হচ্ছে 90 দিনের মধ্যে দেয়।
Suspension or
Suspensionটা দিক imperative
তাছাড়া কি রিপোর্টটা
অল্প হচ্ছে ওরা ট্রান্সপোর্টের ব্যাপারে weekend। Suspension টাকা নিয়ে ওটা ফেরত। Yes.
Page 59B of my stay application. This is my suspension order.
Yes. Yes.
Main reason is I have not visited 3 states. I have misused the funds on account of TA bill. I have not, my lord, traveled with a booking ticket, with a flight ticket. Now, so far as the point that I have not traveled, absolutely false. Why I tell your lordship?
No, your subject matter of challenge in the original application was the order of suspension.
Now the suspension, my lord, kindly sees the order.
Yes. Show us we have 59B. What do you want to show?
59B.
Your writ petition was challenging the suspension and for the direction upon them to transfer you. These are the two folds.
Two. These are the two. Now, my lord,
you did not challenge the charge sheet.
I tried. I tell you, lordship.
No. Was there any prayer in the writ petition?
No. Writ petition was filed on in the month of September, and I got my charge sheet on 3rd of December. Court has recorded that after filing the writ petition and after affirming this supplementary affidavit, my lord, the charge sheet has been issued. I prayed before his lordship, before the trial court, that since I have already affirmed a supplementary affidavit, for additional supplementary affidavit or any other supplementary affidavit or application, kindly grant me a leave so that I can bring on record the charge sheet as well as the reply to the charge sheet.
Charge sheet was not the subject matter.
No, but my lord, but kindly seize your lordship's last order. They rely on Rule 10(1).
You place your case. We have to. Yes, 3rd October 2024, the charge sheet was issued.
Yes, at 1:12 AM.
Now, what do you want to show us from the order of suspension? What is your argument?
There, in the order of suspension, kindly see the last paragraph.
Yes.
The circumstances in which the order of suspension is made are as follows. Sri Diptendu Das, Field Assistant, RRRLF, has been found prima facie guilty of submitting false and fabricated true reports with forged photographs, purported to have visited some libraries and claimed TA by submitting fake TA bills for such visits. It has also been found that, in one of such visits, he has produced an e-boarding pass downloaded by him from the website of an airline without any journey in the said boarding pass and claimed the TA. These lapses on the part of Sri Das are very serious in nature and amounts to grave misconduct. Now, my lord, the money.
Proceeding initiate করে এখানে রিজন দিয়ে দিল যে আমরা প্রাইম অফিসার we have been prime officer into suspension still reply with them. Yes.
They are talking about I have misappropriated money. Now, my lord, kindly takes the earlier page 59. The earlier page 59.
Yes.
This is the refund. When the refund was done, 16th of August 2024. Kindly mark this date, 16th August 2024. And 4th of September 2024, they are saying I have misappropriated the money. I took the money, I accept, and I have returned the money, that I also accept. I wrote to them.
So you speaks of your conduct then?
No, not conduct. I have withdrawn in the month of April. I have withdrawn my report, my tour report, saying there are some typographical mistakes. My hard disk suffers from some technical errors. There are some mistakes. I am withdrawing my letter. I am withdrawing my report. That was in the month of April. And in that letter.
Report as regards what?
As regards, my lord, my tour to Mizoram and Sikkim.
Then
kindly text page 57. This is, my lord, the withdrawal letter, page 57. And in this letter, my lord, I have prayed before them that tell me the modality by which I can refund the money. In the month of April 2024, they kept mum. In the month of August, 16th August, I returned the money. I know the bank account number, so my lord, I have returned the money. 16th of August. 4th of September, they are saying that I have misappropriated the money. The date on which, my lord, the suspension order was served upon me the money was not with me, the money was with them. Because 3 weeks back, I have refunded the money. And April, I have, my lord, on by letter, it's not orally. By letter, I have withdrawn my reports. If they wished to take any step against me, they should have done it in the month of April. Because the Millard tour was in the month of March 2024. Now, Millard.
So what report you filed, which you withdrew?
Millard, my job is as a field assistant, we go to the field of assistants. Millard visits states and different libraries of the states. We, Millard, support financial, we Millard, render financial support to existing libraries. On the basis of our report, how many books are there, how many furnitures are there, what is the condition of the libraries, we take photographs, we do everything, and Millard, we submit report. On the basis of that report, Millard, Ministry, the Director General, accepting that report, forwards it to the Ministry of Millard Secretary and Under Secretary of Ministry of Culture, and Millard Ministry of Culture issues Millard.
When did you
money.
file the report?
In the month of March, I have filed the report. March 2024.
So you report was filed in March, and that was processed, and your the amount was credited to your account.
Yes.
When was it credited to your account?
In the month of March.
So in the month of March, the amount was credited.
Oh, that was not credited to my account. I took that by way of advance. I took that by way of advance. Submitting my TA bills, obviously. Submitting my TA bills.
Without approval of the central government, how can you?
No, it's all about Millard between me and my Director General.
So what did you tell the director? Advance, which application you made for advance?
That application is not here, Millard. That application is not
here. So you went and showed what for claiming advance?
My reports are there. My photographs are there.
No, what was the mistake you commit? Report why you withdrew.
There were, Millard, kindly see the letter, page 57. What I wrote, I said that there are some technical errors and typographical errors in my report. So I am withdrawing the report and I shall furnish a fresh one. Kindly see page 57 to the Deputy Director, IINM, RRLF, Kolkata. Mail for withdrawal cancellation of report, bill number such and such. So bill number has been given. By which, Millard, I got my money.
You got the money in January.
Yes.
You filed the report in March.
I went, Millard, I went to the states, Sikkim and Mizoram in March. I went. That is.
So prior to visit, you raised the bill. Your bill was raised in January.
One is, Millard, 29th January. Another one is 27th March.
Right.
January, Millard, Mizoram tour was there. And March, Sikkim tour was there.
That this is after completion of the tour, you submitted these bills.
Yes.
Then
I submitted the bill.
Before it
without Millard, without going to the place and without spending the money, Millard, I cannot raise the bill.
So
tomorrow, if Millard, tomorrow I am supposed to go, I do not know how much Millard expense I will incur.
Let us understand the facts. You went to Mizoram in January and to another place in March.
Sikkim.
So after returning from there, you submitted the.
I submitted the report. After submitting the report, Millard, I found.
No. Before submitting, after submitting the report, you sought for an advance. That amount was paid to you in the month of. When was you received the payment?
I received the payment, Millard, one on 29th March. That is on account of Mizoram tour. And the other on, Millard, 27 March. That is on account of Sikkim tour.
On that day itself, you got the advance.
Yes. And April 16, Millard, I have withdrawn the report and wanted to know the modality to refund the money. Since I am withdrawing the report, I cannot my lord, hold the money.
Hmm.
Whatever expense I have incurred,
Next,
my lord,
next, then
that
what
may be
happened?
done. Now, 16th August, my lord, I have refunded the money.
They
4th,
issued the suspension on 4th September.
I got suspended on 4th September. They have not, my lord, acknowledged, not done anything. But the receipt, my lord, kindly see page 59. So money was credited in their account.
Please don't repeat. We have heard that.
Now, my lord, so far as the Nagaland, now lordship kindly takes
Now,
a charge sheet.
so your suspension was what ground? What was the ground of challenge of suspension?
My ground of challenge that, my lord, on the date on which I have challenged that CCS was not applicable in my office. Since, my lord, I got my appointment under Raja Rammohan Roy Library Foundation Service Regulation. That time, my lord, I had no copy of the service regulation. Generally, office, my lord, my office do not provide the service regulation to the employees. On the date of hearing before the learned single bench, my lord, the Raja Rammohan Roy Library Foundation service regulation has been produced before the single bench, from which, my lord, it is evident that CCS is applicable in my case. Now, my lord, formal adoption. My lord knows that if CCS is applicable, the office must adopt it. When is the adoption, my lord? Written 28th October 2024. And the...
Where do you find? Where do we find that?
Now, my lord, kindly takes my supplementary affidavit.
So now you are not going back to that. Now CCS is applicable.
Now I go back to CCS because why I tell your lordship, after this kindly takes page 79 of my supplementary affidavit. This is the circular by which, my lord, CGHS, CSMA, CCS, all the rules have been, my lord, accepted. So this is the formal adoption of CCS in my office. And I accepted it, I applied on the basis of this.
But prior to this, the suspension order was issued.
Prior to this.
Suspension order was issued without mentioning under which provision it has been done so. Suspension order, anything referred that this is
one
in the suspension order?
Yes, page 59B. Now, therefore, the undersigned in exercise of the powers conferred by Sub-Rule 1 of Rule 10 of Central Civil Services Classification, Control and Appeal Rules 1965 hereby places the said Sri Dityendu Das under suspension with immediate effect. Rule 10.1. I have handed over the rule to your lordship also.
All official. No. Why did you show page 79?
This is, my lord, formal adoption by which, my lord, CCS has been adopted by my office.
Where do we find that?
Why do you that?
Yes.
You read, brother.
Page 79 of my supplementary.
79 of supplementary
Yes.
affidavit.
All officers and the officials of the foundation are hereby informed that the process of updating the database of employees and their lawful dependents for the purposes of medical LTC CA reimbursement has been taken up, and attention is invited to the instruction pertaining to the eligibility dependency of the family members of the employees for availing medical facilities issued by the Ministry of Health and Family Welfare, Government of India, vide its office memorandum dated such and such, dated 8 November 2016. CGHS and CSMA rules, CEA rules, and CCS leave travel concession rules. So, my lord, 2016 order has been implemented in my office in 2024.
No. Where is the CCA rules applicable?
Yes, my lord, CCS.
Huh?
CEA rules and CCS. It should be, my lord, CCS, CCA rule. First, last line of the first paragraph.
All right. Next, what is
this? Is the document. Now, my lord, kindly takes the. This is formal adoption. Now, my lord, kindly takes the charge sheet. My stay application, my lord, at page 72. Page 72 of my stay application.
এর থেকে আমরা একটা রিপোর্ট করতে পেরেছিলাম, কিন্তু যদি অপোজিশন দিকে আমরা এটা তো পিটিশন ফাইনাল নোটিশে আসছে তো। না না, সেটা ছিল না, সাসপেনশনটা গ্রাউন্ডটা চলেছে, সাসপেনশনটার গ্রাউন্ডটা কি গ্রাউন্ড দিয়েছে, এই সাসপেনশনটা এমনি প্রাইমারি আমি এরকম দেখি। রিপোর্ট করে ওখানেই তো কাজ ট্রান্সফার করেন। Keeping him under suspension should be allowed to join. There's the point. The period of suspension কিভাবে ঠিক করবে সেটা ডিসিপ্লিনারি অথরিটি করবে। পেনশনটা এরকম সাসপেনশন কি ভাবছো? সাসপেনশনটা যদি আজকে আমরা যেটা ওই রিভিউ করতে যাওয়া সাসপেনশনটা হচ্ছে কন্ডোলের ম্যাটার থেকে সাসপেনশনটা যদি আমরা কন্টিনিউয়েশনটা জব করতে ট্রান্সফারটা তো yes, Mr. Nondi, what is the utility in keeping him under suspension? Why do you want to keep him under suspension? You have initiated a proceeding. That proceeding is not under challenge because the writ petition was limited to suspension. Limited to suspension. In the midst thereof, the proceedings have come. He sought for leave to bring it on record by supplementary so that he can challenge the charge sheet also. That was not allowed by the court. Now you have started a disciplinary proceeding. He is participating in the same. And you are not getting any job from him and you are paying him subsistence
I'm
allowance.
not getting anything since 4th of September.
Subsistence allowance you are not.
I have not because my lord, since
The
that time I have challenged CCS, my lord. I have by written they offered me subsistence allowance. I have said since the writ petition is pending, I cannot accept the subsistence allowance because my lord, on one hand I will challenge CCS and the other hand, my lord, I will take benefit of CCS. Both cannot be done. So my lord, from 4th September I am without money. It is my lord mailed to them.
Yes, Mr. Nondi, why you are keeping him under suspension?
My subject. The departmental proceeding has been initiated after being placed under suspension. Suspension, your lordship knows the series of judgment. Suspension is not a punishment.
So why in the suspension you arrived at a
Suspension is
finding
for
that he is guilty?
To ensure the smooth administration of the departmental proceeding, lord. Smooth.
Kindly come to the suspension order.
Suspension, your lordship.
59B.
Suspension pending, your lordship sees. The period shall enforce headquarters field such and such, page 59. Shall be headquarters without obtaining the previous permission. Before
next
that,
page.
my lord, in terms of the 1968, he has been placed under suspension.
Come to that page, 59B.
59B type copy, my lord. Disciplinary proceeding against such and such is incontemplated.
Yes.
Then
So you have suspended.
Yes.
Then why did you write the circumstances at the bottom? That I am suspending for following reason?
Depends has been.
So you made up your mind prior to suspension? You arrived at a prima facie finding. You did not give him any opportunity to reply. Your suspension is in contemplation of the proceeding.
Suspension in contemplation of the departmental proceeding.
Right.
Then
come
charge. Yes, I am coming. Then charge has been issued. When the charge is issued, the opportunity is given to whether he plead guilty or not. He did not participate in the departmental proceeding. The departmental proceeding, as and when, your lordship knows, Janukiram, as and when the departmental proceeding started as and when the departmental started immediately after issuance of the charge. Yes, we have issued the charge.
We are not saying your proceeding
Your
is
lordship,
bad.
the
We are
latter
only on the question of suspension.
suspension,
Suspension, please, Mr. Nondi, tell us that why, when you have issued it in contemplation of a proceeding, that was well and good. But you did it in the bottom.
what additional what I have not the suspense, your lordship knows, suspension is not a penalty. Series of
That exactly.
Observation, your lordship, you have observed
It's
what
not a
the
penalty.
last paragraph it appears. But your lordship, it will be fine when immediate after suspension charge sheet has been issued.
We are not interfering with that.
The
We are
departmental
saying-
proceeding is
No,
going
no,
on.
Mr. Nondi, you have why?
What
was your mind frame?
Yes,
that
I
the
got-
proceeding is contemplated. You are under
Yes,
suspension.
no.
So
Second,
who asked your officer?
last part, the term, last part here in Milord, just bottom reflected. But it is true, Milord. It is true. Charge sheet has been issued. I failed to your lordship, Milord.
No, in criminal respect, it is.
In service jurisprudence, your lordship, those series of as and when departmental proceeding, what is the necessity of suspension?
Why
I have brought all the judgment Miller says the suspension is not a punishment.
Yes.
But observation here in Miller observation. But this observation does not show Miller. This observation does not show the punishment inflicted, penalty inflicted.
But it will speak about your mind determination or
Question Miller to mind,
whether it will
mind, setup, wiredness. I am not that. I am not that. I am only question Miller the departmental proceeding initiated Miller for conducting a departmental proceeding to ensure disposal.
Where is your charge sheet?
Your lordship, I have added the charge sheet.
Page 72. of stay application.
রিপ্লাই মধ্যে আমরা দিয়ে দিয়েছি রিপ্লাইটা রিপ্লাই
না রিপ্লাই আমি দিয়েছি আপনার আর কিছু দেন
আর আমরা দিয়েছি your lordship report in the form and affidavit your lordship will find last occasion we have filed
yes we want to see the charge.
What is the charge your lordship will find? The suspension is not a punishment. Only court can interfere in the order of suspension in 2 paragraphs. If the subsistence allowance is not there, then court interfere to grant the subsistence allowance. We offered the suspension, he refused to accept. So
absolutely they offered by letter.
Will you keep quiet?
Paragraph page 9 your lordship sees.
Yes.
Start from
না আপনি স্টে অ্যাপ্লিকেশন দেখছেন কোথা থেকে
আমি আপনাকে I'm not taking any assistance from you. Your lordship sees the report. I have submitted the report. Last occasion will be copy.
এই এরকম একটা রিপোর্ট ফাইল করেছে দেখো
Yes. Report in the form and affidavit.
Yes, Mr. Nodi.
Page 9. What is the charge?
Paragraph?
Paragraph starts
what you want?
6B at the bottom. Start page 7. No, sorry, 6B. No. Paragraph 6F. Page 9 is the charge.
It was not reviewed. Your order of suspension was. Even if we interfere, Mr. Roy, you have to go and join Guwahati. Because transfer we cannot consider.
Now, my lord, two things. So far as transfer, it's for your lordships.
Thank you also. Distance against
10 years I'm out of Kolkata.
stay evidently. They allow him to join and pay regular salaries.
I have completed my
Yes,
10
Mr.
years.
Nandi. Anything else?
Kolkata.
I only submit this. I have all the judgment also there. The departmental proceeding initiated. Your lordship may direct us to complete the departmental proceeding within the stipulated period that we can do.
You complete your proceeding.
Yes.
Allow him to join at Guwahati.
My lord,
Allot him duties. Extract work from him. Why will you unnecessarily pay subsistence allowance?
now, my lord, so far as subsistence allowance, my lord, since I am without pay from 4th September, my lord, kindly
I am ready to
ask them to liquidate the money.
release the subsistence allowance if your lordship may. I have
Transfer, I
Except for the interpreter. Okay, joint করতে পারি, he will practice the proceeding. This day he will stay করলে interpreter to report করে দিতে আসবে। Yes, Mr. Nandi. This is your argument.
Yes, sir.
And what about the service by 90 days? What is your comment to that?
90 days.
That he was alleging that charge sheet was submitted after 90 days.
No, after not, your lordship kindly sees the report. Report. What is the date?
What is your argument? It was not served upon you within
90 days. On 91st day at 1:12 AM night, it was sent. I have got the track report, page 120, kindly see.
Suspension order 4th September 2020.
No, that is not done. That was served upon me personally at Guwahati.
2nd December 2024.
2nd December, my lord, this was served upon me. Page, kindly takes page 120 of.
Sorry.
page 120, my lord, of my stay application. This is the track report. This shows on 3rd of December at 1:12 on 91st day. So, my lord, and since the order of suspension has not been reviewed under sub-rule 6 and 7 of rule 10, my lord, my suspension from 91st day is illegal. Within 90 days, my lord, I cannot say anything. From 91st day, my lord, it is not legal.
That is in terms of rule
10, 6 and 7.
90 days, Miller, we pay paragraph
10,
4, Miller,
I
I
have
have cited, Miller,
Rule
report,
10,
report,
yes, paragraph 4.
4,
Yes.
page 6. Your Lordship, my report, Miller.
email, my lord, cannot do. I must be sought by hand. Email was sent at 11.
Paragraph 6.
Paragraph 4, page 6. At the top, your Lordship.
Yes. 2nd December. Charge sheet was issued on
2nd December.
and your suspension was on
4th September.
4th September.
90 days, my lord, inclusive the date on which I am getting my suspension order.
So it comes to
2nd December.
2nd December. Now it was served upon you, page 120 on 2nd December itself
3rd December
at 1:12.
12 AM. After 12, my lord, the date is changed.
And which rule you are
6 and 7. Sub-rule 6 and 7, rule 10. This was reflected in your lordship's last order also. It was not reviewed. He can keep me under suspension after 90 days, but that is to be reviewed and a fresh order has to be, my lord, passed. Page 7 of the so in view of this, the suspension from 91st day, my lord, is illegal. I am subjected to, my lord, I am supposed to get full salary from 3rd December.
No review has been done.
No.
Page 8, Miller, report, Miller, your Lordship, is 8, page 8.
Page 8.
Page 8, E. We issued the charge sheet within 90 days of suspension through the email, and that was accepted by the employee.
Email, my lord, cannot.
Email or key acceptance. It is to my forwarded to my email. I will see my email.
It has accepted.
No, no.
Email
Email
if you
cannot be-
send.
The
where
charge sheet was
question I-
also,
Email cannot be-
the charge sheet was also posted to him to his address simultaneously by speed post.
When? When was it posted? It was posted on 2nd December. And where is email service under CCS rules?
No,
That you have sent,
CCS
sent
rule
on,
1965.
huh?
CCS rules, your Lordship knows 1965.
Yes, there is no
Then
email communication. Do you have government notification that email communication is final? এটা বলেছে, এটাকে সেটা সব করবে না, স্টিকার বলে। No review, and আমরা তো দিচ্ছি না premeditated suspension টা। Disclose the circumstances in which the suspension. সেটা যে তুমি একটু full salary পেয়ে যাবে, full salary পাবে on the date you are stopped. সেই পিরিয়ডটাকে রেগুলারাইজ করে দিতে হবে, সেটা ছেড়ে দিতে পারি, ওটা প্রসিডিং এ ছিল।
Then your Lordship, is the F, why suspense, page 8F.
Page 8F.
If your Lordship will find from them. The charge sheet has been issued after taking all the documentary evidence of gross misconduct committed by such and such further necessary action for appointing the inquiry officer has taken into conduct the formal inquiry. Looking to the gravity of the charges framed against him, it is considered imperative to keep the employee under suspension. This is the reason, my lord, for page, my report, my lord, your lord.
Yes.
Page 8.
The present writ petition has been preferred. Challenging.
May I hand over the copy of the judgment based on the trial court, my lord, your lordship directed
Yes,
to
yes, we will refer to that judgment.
No, one another, my lord, that is the second judgment, my lord, the Union of India Ashok Kumar Agrawal. দুটো কপি দিয়ে দিন আমার কাছে কোথায় লেখা ছিল জানেন
Milord, may I make one submission, Milord? I have completed my 10 years service. So far as, Milord, my prayer for transfer is concerned, Milord, is twofold.
para 14 year
My mother, Milord, is a patient of bipolar disorder, and my wife, Milord, is a cancer survivor. Milord,
It's not true.
I am the only person who can take care of both of them. For 10 years, Milord, I am out of Kolkata. I am unable to take care any of
We are
them.
not stopping you. We will make a representation to them for consideration.
Milord, for considering my applications for transfer pending before
That has
them.
already been said by the learned single judge.
Milord, I am grateful. Kindly ask them to consider.
The present writ petition has been.
Paragraph 15, your lordship can see on the sorry, my lord. Only I have
Boshu. Yes, Mr.
paragraph 15. Union of India versus Ashok Kumar Agrawal, the judgment cited by the trial court data case.
Paragraph 15.
Paragraph 15. একটা কপি দিয়ে দেবো দিয়েছিল না আগে থাক লাগবে না
It's in my favor. Paragraph 15. It talks about Rule 10(6).
Mr. Roy, you are speaking too much. The present writ petition has been preferred. Challenging an order dated 16 December 2024, passed by the learned single judge in the writ petition being WPA 23843 of 2024. The said writ petition was preferred by Diptendu Das. He said challenging order dated passed in a writ petition being such and such, preferred by the writ petitioner, comma, namely Diptendu Das, bracket in short Diptendu, challenging inter alia an order of suspension dated 4th September 2024, passed by the respondent number passed by the Director General, comma, Raja Rammohan Rai Library Foundation. Library Foundation. And for issuance of challenging the and the inaction on the part of the respondents to consider Diptendu's prayer for transfer to Kolkata, to prayer for transfer to Kolkata. By the order impugned, the learned single judge has dismissed the writ petition observing inter alia that there was no irregularity or inconsistency in the order of suspension. Inconsistent stop. Mr. Royal Learned Advocate appearing for the writ petitioner stroke respondent number appearing for the appellant submits that the impugned order of suspension was issued in a whimsical manner by the respondents. Stop. The order itself would reveal that the respondents were predetermined to issue the suspension order and to keep him under suspension for an indefinite period. He argues that in the order of suspension, though in the first paragraph of the order of suspension, it was stated that Diptendu is being suspended in contemplation of a disciplinary proceeding, comma, the purported reasons towards such suspension, the purported circumstances in which such order of suspension was passed was also detailed at the bottom of the said order. The order thus reveals that he further argues that the suspension order was issued under Rule 10 bracket 1 of the Central Civil Services bracket classification, comma, control and appeal bracket close rules 1965 bracket hereinafter referred to as CCS rules করে দেবে CCS rules. Stop. Rule 10 of the CCS rules provides inter alia that an order of suspension issued Rule 10, order of suspension issued needs to be reviewed by the competent authority before expiry of a period of 90 days from the effective date of suspension. In the present case, no such exercise was adopted by the authorities, and the appellant was placed under suspension indefinitely. Drawing our attention to page 120 of the stay application, he submits that the charge sheet dated 3rd December 2024 was sent to the appellant by email on the 91st date at 1:20 hours.
Charge sheet dated 2nd December.
Charge sheet dated 2nd December. Stop. And as such, the respondents had no authority to keep the petitioner under suspension any further. Stop. Mr. Nondi, learned advocate appearing for the respondents, however, denies and disputes the contention of Deeptendu and submits that order of suspension is not an order of punishment. Stop. Taking due care and caution that after taking into consideration and after taking all factors into account, the respondent issued the order of suspension, and there is no infirmity in the same. He further argues that the charge against Deeptendu is of Stop. The charges against Deeptendu are very serious, and in the event and in view thereof, revocation of the order of suspension would severely and in view thereof, he needs to be continued under suspension, since there is every possibility that he would interfere with the evidence. Stop. Interfere with the disciplinary would কি লিখেছ? Since his continuance in office would prejudice the investigation. In support of such contention, reliance has been placed upon the judgment delivered in the case of such as Union of India and another versus Ashok Kumar Agarwal, and in the case of Jairaj Bhai Jayanti Bhai. Drawing our attention to the amendments made in the report filed in the form of an affidavit, as directed earlier, Mr. Nondi submits that suspension is an executive action whereby an employee is kept out of duty temporarily pending final action being taken against him. Stop the disciplinary proceeding has admittedly been initiated, and that as such, the Diptendus, and that as such the petitioner, and that as such the challenge against the order of suspension was rightly turned down by the learned single judge. Stop in view thereof. We have heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. In a given case, prolonged suspension on account of sheer inaction on the part of the appointing authority may be unjustified, and that the period of suspension should ordinarily not be unnecessarily prolonged in the absence of any plausible reason. If the employee is kept under suspension, the employer is required to pay him subsistence allowance without taking any service from him. Stop. Next paragraph. The order of suspension was issued stating the circumstances in which the same was, stating the circumstances which necessitated the issuance of the same. The concerned, the disciplinary authority, while issuing the order of suspension, observed that Diptendu has been found prima facie guilty of submitting false and fabricated 2 reports with forged photographs. And he has produced an e-boarding pass downloaded by him from the website of the airlines without any journey in the said boarding pass, and claimed TA. It was also stated that such lapses on the part of Diptendu are very serious in nature and amount to grave misconduct. Records, however, do not reveal that any opportunity of hearing whatsoever was granted to Diptendu prior to arriving at such prima facie finding. Prior to finding of such prima facie finding. In view thereof, it appears that the same had been issued. In view thereof, it is very difficult to rule out. That prior to issuance of the suspension order, a prima facie finding on guilt was arrived at by the respondent. Stop. Records further do not reveal that the authorities took and made any do not reveal that the order of suspension was reviewed prior to communication of the charge sheet by email on the 91st day, after issuance of the charge sheet. Stop. The judgments, there is no dispute as regards the judgments upon which reliance has been placed by Mr. Nandi. However, the same are distinguishable on facts. In the said conspectus, we are of the opinion in the said conspectus, we are of the opinion that the order of suspension is not sustainable. Accordingly, the impugned order of suspension dated such and such is set aside. However, we have been informed that the subsistence allowance pertaining to the period of suspension was offered to the appellant, but he refused to accept the same. In view thereof, the respondents are direct. In view thereof, we direct that the petitioner, that Diptendu would be refuse to accept the same. Due to pendency of the present writ petition. Due to pendency of the proceedings. Stop. As we have arrived at a finding that the order of suspension is not sustainable in law, as we have added the same is set aside. The respondents are directed to disburse regular salary to Diptendu pertaining to the period from the date of issuance of the order of suspension till date, and are further directed to continue disbursement of regular salary on and from the date of joining of the petitioner in terms of this order. Stop. The petitioner is further directed to and to disburse the regular salary after he joins the post. After he joins the post at Guwahati. In the writ petition,
Writ petition is with the supplementary affidavit.
ট্রান্সফারের ব্যাপারে একটা কি বলেছেন? However, we are not inclined to interfere with the direction of the learned. বলার দরকার নেই। এই যে প্রেয়ারটা কি লাস্ট লাইনটা কি বললে? And next paragraph, as regards Diptendu's claim for issuance of necessary direction upon the respondents to transfer him to Kolkata, the learned single judge has observed inter alia that such prayer is left open for sympathetic consideration by the employer. হুম। আচ্ছা ওই ওখানে দেখো এক জায়গায় বলেছি
On the date of
no review from the date of issuance of from 90 days from the date of issuance of the order of transfer suspension as per rule 10(7)
7.
as per 2 rules.
এখানে সাবসিস্টেন্স জানানো দেবে 3 মাস বাকিটা
ইয়ে তাহলে ওইটা কেটে দাও রেগুলার স্যালারি সাসপেনশন যদি একটা সেট সাইড করে রিভিউয়ের কথা তো বলছি না যার ফিচার the transfer is petitioner cannot prevent. Now, it don't go. As regards the petitioner's claim for transfer, we do not find any infirmity in the observation made by the single judge that না রেগুলার স্যালারি বলেছো তো আরেকটা প্যারা দিয়ে দাও as regards Dityendu's prayer for transfer to Kolkata in view of the ailments being suffered by her mother and wife would be is left open for sympathetic consideration by the employer. With the above observations and direction, the appeal and the connected application are disposed of. There shall have
I'm grateful, madam.
একটা লাইন লিখে দেব দি জয়েন করতে করতে এক সপ্তাহ the appellant is further directed in view of the order passed the appellant is directed to join his post at Guwahati.
Kindly fix a date. On that date, my lord, I shall join. Kindly fix a date. Both of us are here.
Within in a week.
Within a week?
Has been
within a week from date.
Within a week from date.
Order will be served tomorrow. This order will be uploaded served tomorrow.
Parties to act on the basis of the server copy.
No, you will get the server copy tomorrow evening. You will get the server copy.
Yes, Miller, kindly record that parties would act on the basis of the server copy.
Parties will act on server copies of the order. The date within একটা date আজকে কত তারিখ?
So today is 4th.
Within 12th March.
Miller. I'm extremely grateful, Miller.
Item number 12, I am for the appellant led by the learned Advocate General. He has concluded his argument on the other day. And the 13 is the appeal preferred by the state against the same judgment and all.
এই তো গতদিনকে বললি যে আবার কিছু বলবে কিছু বলবে
For the state.
He is appearing for the state in item number 13, right?
I am led by Mr. Shaktinath Mukherjee. In fact, the learned Advocate General has argued both for on behalf of the state as well as for the requiring body.
Mr. Pan, we may not be able to finish it today. We will hear you on a particular date.
No, Madam, kindly, then, Madam, I request your lordship.
Next week.
Madam, kindly, yes, Madam, any date, a time may be fixed, Madam, so that we can come before us.
Mr. Pan, the problem is we fix the time. We have already fixed 2 p.m. matters from today on.
Yes, my lord. We appreciate, my
We will
lord.
keep
Kindly.
the matter, it will be fair up so that we can hear and finish.
Be kind to us also, Milord.
Yes,
Be kind to us also. Your lordship, this other matter, this some other date for us.
yes, Mr. Mukherjee. Keeping it on
Very well. Any date.
স্যার মঙ্গলবার দিন রাখছেন জজ সাহেবরা
Very well, Milord.
You tell us, Mr. Mukherjee, when you
No,
can.
no, your lordship's convenience. It's Tuesday. We'll be there on Tuesday.
টুইসডে
18 তারিখ।
না টুইসডে তাহলে আমরা বলবো তো তোদের তো
We are keeping it on 18th, Mr. Mukherjee. 18th is a Tuesday. Tuesday week.
Very well, very well.
18th is too long, my lord. 18th is too long.
Right, you got.
My lord, one more thing, my lord, one more thing. স্যার ওই এটা এক্সেপশনটা ফাইল করছি my lord.
ফাইল করে রে
তাহলে 19th এ রেখে দাও। 19 PM হ্যাঁ ফাঁকা আছে 19 2 PM
19 2 PM.
My lord, deeply obliged.
What you are
19 PM.
filing, Mr.
My lord, this is an exception, my lord. A report in the form and an affidavit was filed. My lord, kindly allow us to file the exception to that report. In fact, my lord, we have not pleaded anything new and state on the record already.
Something formal.
It is Mr. Dotto. He took time, na?
His junior is here.
So where is he, sir?
দাঁড়া ওরকমভাবে দিচ্ছ কেন দাও না ইয়ে নেই চিঠি করে কেন দাও না my lord.
Let the exception to the
Yes.
report filed on behalf of the state. Mr. Pan, learned advocate, appearing for the respondent number 1 writ petitioner, files an exception to the report filed earlier on behalf of the state respondent. Let the same be kept on record.
My lord, copies, my lord, I have already
Copy of
served.
the same has been it on learned advocate appearing on behalf of the state respondents in court today. So please the matter for further matters taken for further consideration on 19th March as fixed at 2 PM.
Deeply obliged. তোমার দেখো এগুলো কোনো সেলাই করেছে
এটা টিপলে এটা যেমন আছে তো এটা এরকম টাচ করলে এই লিপ আসবে আবার করলে
এই বাঁচলাম
হ্যাঁ
কি বাঁচলাম
না এটা অন করে দিলে তাহলে আমার এটা
Lordship, I'm appealing behalf of the appellant petitioner's lordship. Lordship, on 28th January, my lord directed me to cure the defects, lordship. In the cause title, I have already cured the defects, lordship. Few petitioners' name were unfortunately typographical mistakes were there, lordship. And there is a delay to file this appeal, 198 days, my lord. And the same cause title defect was there. I also removed the defect, lordship. The main application was that, my lord, and paying compensation, lordship, for the land acquisition, I made a petition before this honorable court, lordship. Few series of DAG numbers were there, lordship.
Section 5 is there.
Yes, my lord.
You are appearing for
the state, my lord.
your state.
I am for Asansol Durgapur Development Authority.
The section 5 you are opposing.
My lord, we are leaving it, my lords.
Only thing, my lord, your lordship will see the impugned order where, my lord, they have petitioner has been permitted to withdraw the writ application with liberty to file afresh. Now he is saying that that was not my submission. If that be so, then why he filed the appeal after 190 days? Kindly consider that, because
lordship,
he should have gone back immediately to the court and said that this is not my submission.
My lord, the thing occurs that the petitioner number 2 is the only person who always came to honorable court lordship for the affirmation of the all applications in the earlier writ petition also and this. He becomes ill and the petition number 1, the Namita Mandal is aged lady. She also become ill. And the petition number 2 look after the petitioner for the long gap. He did not appear before me lordship. Did not came to courtship. I did not affirm the applications lordship.
My lord, if there is any error in recording the submission, they ought to have filed a review application.
Immediately before that court.
Review application.
Lordship, it's true. But another appeal has been preferred by the state, which I have owned, the previous matter, which I am praying for the same order, which is pending from February 2024 till today, lordship. It has not been appeared, lordship. They have challenged that order. If that
Which order? Which
lordship? Initially, I came up before this honorable court seeking land acquisition compensation for the some DAG numbers, lordship. I own in this matter, lordship. They are in typographical mistake. 4 or 3 DAG numbers are missing by me, lordship. Advocates missing, typographical missing, lordship. Thereafter, lordship, when the judgment came out, I found out that these three DAG numbers are not there, lordship. I prefer fresh writ petition seeking same relief, lordship, same order in compliance of in light of the earlier order, lordship. I failed to submit, or lordship, it is on failure on my part to clear that in that writ petition, those 3 DAG numbers are not there. The court passes an order that I made an mistakes in this writ petition, which I came up before this honorable court in appeal, lordship.
The state preferred an appeal against that order.
That order, lordship.
What happened to that?
Lordship, from February 2024, lordship, till the matter has not come up before any court, lordship. It is one.
Show us that order which was passed by the single judge.
My lord, at page 96 of the application, lordship.
So state has preferred an appeal against this order, which is pending before us.
Yes, my lord.
So any order was passed in that?
Not a single day it was listed, my lord. And after 4 months, they have.
So, Mr. Banerjee, are you there in that appeal?
No, lordship, in that matter.
Mr. Shah is appearing for ADA in that matter also, but I am
Mr. Shah is appearing both the matter, lordship.
For
Mr.
ADA.
Shuddhadev Adav is the advocate on record, lordship.
Siddiqui must be
MAT,
appearing.
yes, my lord. Mr. Siddiqui probably the 296 of 2024.
So where are the DAG numbers you have mentioned?
Lordship.
What is the number of that appeal? What is the number?
296 of 2024.
2024, lordship.
ওটা কি এটার সাথে আনতে বলি? Give the number, it
My
will
lord.
appear along with this.
Lordship, appeal filed before that
one technical point, possibly Mr. Siddiqui will also take note. Suppose he can ask relief for 10 DAG numbers, he seeks for 7, then the rest 3 also becomes res judicata, constructive res judicata, because it shall be presumed that you have paid relief for everything, whatever you can get. Explanation 4, possibly 4 to Millard, section 11 says that if a matter is decided, then it shall be treated as issue decided in respect
I understand, Mr. Banerjee, but
that is a technical.
contention is there were some typographical error. If that is bona fide, then we
My
can.
lord, lordship will not. 226, your lordship can.
অ্যাপিলের নাম্বারটা দিয়েছেন?
দিয়ে দাও 296 of 20.
Where is your stay application? Where you have stated that some
Lordship, paragraph 13, page 32, lordship.
Paragraph,
31, my lord.
all the private respondents served.
Lordship, no private response.
Oh, you are the claimant.
The petitioners are
Oh, paragraph
paragraph 1-3, my lord.
of the
Application, lordship, stay application.
1-3.
Yes, my lord.
1-3 is list of dates.
13, my lord, paragraph 13.
Condonation.
Running page 32
Running page 32, my lord.
of the stay application.
32. No, your this is your writ petition.
No, my lord. This is
Stay application.
This was the writ. You have you are showing us writ
Yes,
petition.
this is the annexure, writ petition. Annexure to the stay application, right? Annexure P1 starts from page 12.
Or Mr. Banerjee, we can set aside this order and ask the trial court to decide on merits, and that will be subject to the appeal which is being filed, which has been filed.
Right. Because
Lordship, my
one forum is because it was not decided there. So your lordship is right.
Lordship, my
My-
submission.
Because if it is his case,
দেরি হয়ে যাবে।
Lordship, my submission is that if both the matters taken up together, the appeal preferred by the state, lordship, if I succeed, both the matter will be, lordship, in the single bench, my lord. Today's the
Ashok,
matter-
Mr. Ghosh,
My lord.
Mr. Ghosh, learned advocate appearing for the appellants, submits that initially by an ordered by a judgment dated 17th October 2023, delivered in a writ petition preferred by the appellants hearing, being WPA 5412 of 2016. Directions were issued towards payment of compensation pertaining to the plots of land detailed in the writ petition. However, mistakenly, some of the plots of land stated in the writ petition were not included in the impugned judgment.
Not in judgment, lordship. In the writ petition, I did not trade, lordship. In the prayer portion, I did not trade, and the body also those dark numbers were not mentioned.
Then his argument is correct. When you have not taken that point, constructive res judicata will apply.
Lordship, the issue decided whether the land act, my submission is that, lordship, the issue decided whether I am entitled to get the compensation or not, lordship. And those dark numbers inadvertently mistake by me, lordship, during the first writ petition, I did not type it or inadvertently mistake.
কি লিখেছো? কি লিখেছো?
technical point নিয়ে লাভ নেই।
No, however, certain plots of land were inadvertently not detailed in the writ petition. In view thereof, the writ petition again filed a writ petition being WPA
lordship,
such and such, which has been WPA
14535 of 2024.
One, what is it? Number
535 of 2020.
illegal line ten? Not detailed in the writ petition. In view thereof, the writ petitioners have filed a fresh writ petition বলেছো তো? Again filed a writ petition being WPA such and such, which was dismissed by the order impugned in the present appeal. He further submits that challenging the earlier judgment dated 17th October 2023 passed in WPA 5412 of 2016, the state had already preferred an appeal being FMA
MAT 296
of
96.
2024, my lord.
In view there, in view thereof, list the present appeal along with the appeal being FMA such and such for consideration in the daily supplementary list of this court on 18th March.
Well,
18th March. Stop. The appellants are directed to intimate this order to the learned advocate on record on behalf of the state, or learned advocate on record of the appellants in FMA, ওইটা বলে দেবে immediately.
well, deeply. No, if you may.
ওনাদের নাম দিয়ে দিও।
Only one thing, my lord.
Yes.
In my case, in the writ petition, I did not get any chance to file any report or affidavit because whether those ducks and the other writ petition was heard upon affidavits, 2016 matter.
We
So
will
I-
send it back.
My lord,
If
that is better.
the pending writ petition, if we sending back, it
Yes.
will be subject to the order.
Subject
If
to order
we
in the appeal.
interfere.
Well, if my lord allows the reports filed by them lordship, may I be permitted to bring before the my lordship?
If there's a direction, if the matter is sent back, then I'll file the report.
Okay,
You bring copies of this.
my lord,
report,
I
take it up.
definitely deeply appreciate.
Yes. Next.
But I beg to appear on behalf of the petitioner.
I am for the Union of India. Mr. Pramod Dolia is due to personal difficulties, he has not come to court today. I am praying not today.
This can one is six.
Not a stay.
Still.
In fact, the whole appeal can be disposed of when your lordship takes up the matter. I am not standing in the way of adjournment because the gentleman hasn't come personally. But the issue is very short. Section 80 of the Fair Compensation Act 2013 has been read into the Metro Railways Act. By reason of a notification issued by the Government of India. Now, Lord, in computing the compensation, Section 80 has not been resorted to. That's the grievance with which we have come. And Lord, the learned trial judge, perhaps Lord, missed the section in delivering this judgment because Lord, there was an earlier occasion where Lord, we challenging the compensation we had come up to the court under Article 227. And Lord, there the court Lord reduced the compensation because the appellate authority had increased the compensation, reduced the compensation to 52 lakhs. This payment we received subsequent to the order of 227. And Lord, at the stage of final computation, this section 80 had to be applied, which was not applied. When the matter came up before the learned judge under Article 226, the learned judge took a view that you did not take this point, or rather you raised the point, but the court did not go into it at that stage. Correctly, because Lord, at that stage, the time had not matured. Section 80 would be applied at the stage of final payment, not before that. So this is the time, Lord, when we came in Article 226 saying that in computing the final computation, this Section 80 has not been factored in. Lord, I don't ask for statutory interest before the authority. Statutory interest is provided under the statute. While computing, this statutory interest has to be given. This is the short point on which, Lord, this petition is rested.
On that ground, it can be done away with. No? There is nothing to contest in the matter.
Tomorrow, Mr. Dolia will come.
Heard Mr. Ford Learned Senior Advocate appearing for the appellant. Today, however, an adjournment has been prayed for on behalf of Union of India. In view thereof, the matter stands in view thereof, the matter stands adjourned. কবে রাখবে বলো তো, কবে date আছে? In view thereof, list the matter for further consideration under the same heading in the daily supplementary list of this court on 19th March.
Much obliged.
চলো একে ডেকে দাও। মামলা স্লিপটা দাও। হ্যাঁ এটা ওই হিন্দুস্তান মোটর come tomorrow. Take it up.
Well, may I just indicate one thing, Millard? Millard, 6-3 challenges 6-3 Estate Acquisition Act. On the last occasion, Millard, we
said something.
No, your lordship said that your lordship is hearing
The
two
other matter.
separate appeals
Oh, acha.
on the same issue. Then we found out that maybe some issues may overlap, but not the entirety. We have certain additional grounds which we found out is not being argued in the other two matters. So from the order sheet, it transpires that in one matter, Mr. Shoptangshu Basu, appearing on behalf of the petitioner, has concluded his submissions.
Yes, that is that matter. When have we kept it?
Brand Smithy works, perhaps. And the matter was
One is Lakshya Trade Links.
Oh, that is appearing today 2 p.m.
Right, right.
We kept your matter. That is why we kept your matter today.
Right.
So
We can come back at 2 p.m. Though our point is in addition to what has been argued.
We do one thing.
My lord.
We will if it is not completed today,
My lord.
on the date on which we will keep your matter also on that day.
Very well.
So that if they finish, if you have to point out anything else, you can do so.
Our challenge is
On
entirely
different grounds, you will argue. We will not shut it.
My lord, before my lord rises, just a small, may I bother my lord for a while? I have come from Port Blair, my lord. There is one intra-court appeal which I want to file. Move it. There's an urgency. I was not in the mentioned timing, my lordship. Just now I have arrived from Port Blair. The writ court has turned down an interim prayer. The Tahsildar Port Blair has fixed the eviction order to be implemented tomorrow. There is some urgency, my lordship. My lords, allow me to move the appeal and application in the afternoon or after the lunch hour, my lordship. I would be grateful, my lordship.
But who is your other side?
My lordship, I've served the notice. A advance copy has been given. I'll file affidavit of service in course of today. I've served it before coming to Calcutta, my lord. Tomorrow, if the order is
here, could have apprised us. And now today, why you are going away today?
No, today I have come, my lord. I'm staying back, but the eviction order would be implemented tomorrow by demolishing my building. The writ court have not granted me the interim
At
period.
what time hearing has been fixed?
No dates. Eviction order has already been passed. I filed a writ petition. It was simply admitted upon exchange of affidavit. No interim protection was granted. Against which this intra-court appeal, I have prepared it, I brought it.
Sen, you are appearing?
No.
Oh.
No, sir, I am just seeking a leave so that I can move it, my lordship, in course of.
But we cannot take it up expert enough. We have.
I've served it, my lordship. No, I've served it. I've served the notice.
Appearing Port Blair. Miss Bobita Das appearing.
Yes. No, not by Justice Bibas Chandran, my lordship, the interim order was turned down. Yesterday was the last day of the circuit. But I've served the advance copy of the appeal also can.
We have to publish a supplementary list then and keep it.
Some
There's the
urgency.
problem.
Otherwise, I could not have bothered, my lord. Because tomorrow is the deadline date fixed for eviction. That's the whole difficulty. I had been 2 days more, much I have to stay back in Calcutta.
Supplementary bear korte hobe.
In the petition, who appeared on behalf of Tahsildar?
Babita only. She appears, she being the government player, she appears for all Tahsildar in every matter.
এটা কি ওই লিভ গ্রান্ট করে দাও আর ওটাকে একটা সাপ্লিমেন্টারি বেড করে দাও না 3টের সময়।
3টে হবে না 3:30 এই ম্যাটারটা চলবে। ये के दिते হবে ওখানে অ্যাডজাস্ট করতে প্রায় 3টে না 3:30
3টে তো
Okay. So we are keeping it active.
I'm grateful.
you sent one email as well as orally you informed
Perfectly.
Ms. Bobita to join online.
Perfectly, perfect. I'm grateful. I'm grateful. Before rising, Your Lordship, my lord, I'm very sorry to my lord, disturb Your Lordship, my lord. Item number 9 is a very, very urgent matter, and my lord was kind enough to my lord fix the matter today. Item number 9. My lord, I was held up in other court. My argument was going on. I could not come. My junior was also
What
other
we have done?
my lord, adjourned for a week. But in the meantime, what happened? Twice the
12th we have kept.
12th. Now, my lord, what happened, my lord? The 7th is the date fixed got contempt application on the in the last week. My lord, the learned judge, the honorable judge said,
Your other side.
my lord, upon notice, my lord, say, kindly take it any day, my lord, before 7th, lordship.
So not today.
Day
Item
after
number 9,
tomorrow.
not today.
Day after
Day
tomorrow.
after
Day after tomorrow, item number 9. And grateful, lordship.
Day after tomorrow করে দাও।
Grateful, lordship. Day after tomorrow, মানে হচ্ছে
এটা তো রিগার্ডিং সাবমিশন অফ পেপার, আপনার দেওয়ার ব্যাপারে তো কিছু নেই, পার্টিরা কালেক্ট করবে।
আচ্ছা, আপনাদের ডিপার্টমেন্টে কি অ্যাভেলেবেল আছে? স্পেয়ার কপি নেই?
নেই তো। সার্টিফাইড পেপার বুকের আপনার সার্টিফাইড কপি যে বলবো ওটা করবে কোথা থেকে? আপনাদের রেকর্ডেই তো পেপার বুক।
এটা আমাদেরটাই নেবে? হ্যাঁ,
ও আমাদের সেটার জন্য ওকে কি সার্টিফাইড কপি অ্যাপ্লাই করতে হবে? এই কার্তিক, তা তুই ফাইলটা জাস্ট নামিয়ে দাও, ফাইলটা জাস্ট নামিয়ে দাও অ্যালং উইথ দি পেপার। এবার ওদেরকে বলে দাও সার্টিফাইড কপি আপনারা অ্যাপ্লাই করে দেন।
প্লেন কপিও করতে পারেন, এটা আমাদের অর্ডার দাও। আপনারা তো নিজে থেকে প্লেন কপি দিতে পারেন। তাহলে এবার আমাদের আবার একটা ডেটে আনতে হবে, সেই দিন অর্ডার দিতে হবে, তবে আমরা প্লেন
ফাইলটা নামিয়ে দিচ্ছি, ও কালকে সার্টিফাইড কপি অ্যাপ্লাই করে দেবে, তখন ওটাকে প্রসেস করে দেবে।
ওটা তাড়াতাড়ি করে দিতে পারবে।
মিস্টার মজুমদার, you make a formal application for certified copy of the paper. We are sending back the file to the department. You make that application, thereafter on that basis they will pursue. Yes, next call.
না না টাইম পাই, রোজ টাইম হলে জজ ভুলে যাবে সবাই। I don't find they are supposed to reply. This is the non-legal tenancy act matter, my lord.
Mr. Galib is coming.
গালিব, হ্যাঁ গালিব এখন শায়রি লিখছে নাকি?
আসছে, আসছে।
Then in the meantime, I recapitulate, try to recapitulate. I think my lords have taken an extensive note. Next পরে আগে এটা হোক। কালি তো শায়র লিখবে, ও শুনছি এইসব করছে কেন কে জানে। মোহাম্মদ গালিব only to write poems, তা না ওকালতি করতে চলে এসেছে। আমার কত
ও
আগের দিন তো হয়ে গেছে।
না, আপনি কি এটা বলবেন বলছিলেন না, যেটা কি এটা
মামলা বলা হয়ে গেছে, পরে
স্টার্ট করবো।
করবি, শেষ করবি, সব করবি।
লর্ডশিপ, may I start today?
আগে জার্সি চ্যাটার্জি নোটটা, my lord got the your lordship's note.
Yes.
Should I?
What you want to remind anything else?
If your lordship requires, otherwise I will not travel your lordship.
No, yes, tell us what you are.
Yes. My lord, this is in respect of a land which was purchased by court sale.
Purchased by?
In court sale. And record of right, it says Bossos Poja. So it is a non-edical tenant. Irrespective of the fact whether prior to 1955 it was local car or not, it should be cannot be vested. The trial judge, the tribunal has stated on the basis that the Thika land. Without going through the ingredients of Thika, my lord, if it is, even if it is applicable, Thika, then my lord, it has to be a lease of vacant land with a right to construct and Kacha construction. So these ingredients are not there. This is only, I find this is the only point I have to canvass with. The Thika has no manner of application so far as these matters are concerned. My lord, kindly once look to page 57. Kindly come to right hand column, Bosot Proja. Bosot Proja. And my lord, same your lordship will get at page 60 also. The name of my vendor is there, Howrah Trading Company. Has Justice Chakraborty kindly got?
Yes.
Page 60.
Yes.
Kindly see the left hand side, Howrah Trading Company, my vendor names is there, and right hand side, Bosot Proja. And kindly come to 101, just for Rakship recapitulation. My lord has seen this everything.
Mutated.
Muted. I have shown to lordship a land manual which said his proceedings of mutation is a self-contained code. But my lord, everything has to be looked into. Whether it is land is vested or not, acquired or not, everything. There is a manual. I have placed with the black. So I can presume, my lord, when the mutation has been granted in my favor, all these paraphernalia formalities have been complied with. If it is complied with, now you cannot go back to the earlier saying that it is land is vested. We cannot say this. This and now why the initially, my lord, mutation was granted. Now when so on the basis of mutation, I can apply for conversion. I have applied for conversion. When I applied for conversion, the genesis of this matter, they again said that you have to apply for fresh mutation. I don't know why. When there is a mutation in my name, and why the second application of mutation was filed, then this problem cropped up.
There was an order rejecting the mutation and the second term.
No, first to be satisfied, but 101 mutated in my name. Then I went for conversion. When I went for conversion, they said you have to apply again for mutation. And when I second time applied, rejected.
That is page?
That is page 110, brother. Yes, 110. This is 14th March 2022. Notice duly served, hard petitioner such and such. The applicant applied for following schedule will be recorded in his favor with virtue of document examined and documents produced by examined the documents produced by the petitioner and the investigation report is found that the applicant has obtained the suit property while registered instrument transfer with such and such. Claim plot does not match with the field verification. Petitioner does not possess the plot of document produced do not match with the claim. Not satisfied and hence rejected. So my another point is here, the so-called investigation report has not been produced while rejected, served upon me. Then my lord, appeal court 54 under section 54, paper and appeal was dismissed. Order 133, kindly come the order of dismissal. Order dated 20th September 2022.
Yes.
So this is the rejection.
Against this, you went to tribunal.
Went to tribunal. Now, my lord, one document I want to show to your lordship. The dispute cropped up among the state government that what is the nature of the property, whether it is non-legible or not. Kindly come to 136. This is the notification dated 14th September 1994. In supersession of all previous circulars instruction relating to accounting of vesting of non-agricultural lands, it is clarified that all non-agricultural lands belonging to erstwhile intermediaries and right shall vest if found excess to the state within such and such. Section 3A, kindly come to 2. Exclusively non-agricultural tenants like Dakholkar, Chandina, or Dakholkar Basat Koja, etc. of all grades were outside the purview of West Bengal Land Reform and will be stated as Dakholkar only. Then kindly turn over. The system of intermediary was in extent to up to 1890, that is the day before Section 3A Act came into force. Hence, there might be a Dakholkar under tenant under Dakholkar before 19, not necessary for our purpose, but this was clarified. Then, my lord, kindly come to 4. All types of Dakholkar tenants would hold any quantum of land in first possession, and in WB Extension Act, no land of Dakholkar of any type was vested. Then, my lord, kindly come to 6. The exclusion. The erstwhile intermediaries like Maliki, Madhyasatta Bhugi, etc. was held agricultural land, orchard, tank fisheries, etc. along with other non-agricultural lands were never a person like Dakholkar and never were guided exclusively by the West Bengal Non-Agricultural Tenancy Act. The non-agricultural land held by them was very much under the purview of sealing under the provisions of the West Bengal Executive Act, and as set down in section 6(1)(c), they could retain only 15 acres of land maximum as right. So this is the exclusion. I am not coming under the exclusion, I am the original first part of the notification. So this problem cropped up whether Basat Koja will coming under the non-agricultural tenancy or not, that has been clarified by the government itself. And I have cited judgment, my lord has taken note of that. Yes, yes.
15.3 CHN 658, 17.3 CHN 97.
File.
And 2023 SCC Online Calcutta 306.
But what will you find in when?
2005 Calcutta 190 was also referred by you.
Yes, that was referred.
And 19.2 CLJ.
19.2 CLJ can you
582.
Just a minute. অভিজিৎ রায় আপটা রিপোর্টার Yes. But one thing before I take my seat, the Lordship will not find any order where my mutation which was granted, how it can be evaporated. There, my lord, mutation was granted, holding that I was a non-agricultural tenant. And mutation granted in my favor because I have purchased the property by court auction, and my vendor names I have shown to your lordship in the record of right is there. Holding it is a Basat Praja.
So mutation does not create any
title. I'm not saying title. My status.
For the purpose of retention.
Except title, my possession can be there. Description of the land is there. That can be proved. I am not asking for title by mutation. I am submitting, my lord. The nature of land, non-agricultural, that evaporates by subsequent order. My status evaporates. How? I am asking the question. So no, not a single line you also will find. So, my lord, as of now, there is no reason for cancelling the. In effect, it was cancel my earlier mutation. I need not file any subsequent application for mutation. At my lord, they are not granting my 4C. That's why I am compelled to file it. And the result of compulsion is this. My original status goes.
No, the tribunal said that it was coming under trigger tenancy. Show us that paragraph. That is internal page 5.
Well, I am showing to you. Yes, 5. The extent of applicability. Well, kindly in the bottom. Kindly in the bottom. The applicability of the Kolkata Theatre Tenancy Act, as mentioned in section 1 of the said act, has been specified wherein it has been specifically mentioned that the Kolkata Theatre Tenancy Act 49 extend to Kolkata as defined in clause 11 of section 3 of the Kolkata Municipal Act and to the municipality of Howrah. Accordingly, there is no doubt that the provision of the West Bengal Non-Agricultural Tenancy Act 1949 cannot be applicable within this. Well, absolutely, my lord, totally non-application of mind or non-understanding of the law on this subject. FICA may apply if the ingredients are fulfilled. But let me take this. One thing, my learned junior has rightly pointed out, the mutation granted by the status of the officer has been negated by the same status, not the higher status. Whether in administrative law, whether that can be done. That's all.
Yes. That's all.
Anything, any query for my lord?
Let us hear Mr. Galib.
No, if you also have any query, my lord, I am.
No, when same status, do you want us to send it back to him, the hired officer?
My lord, in respectful reply to the submissions of my learned senior friend lordship, if I have understood rightly,
Just one second. তুমি এক জায়গায় কোর্টকে একবার ওই প্রভিশন থেকে থাকলে তুমি গভর্নমেন্ট আবার ওটাকে চেঞ্জ করিয়ে নিয়ে নিতে পারে না, এরকম একটা কি গল্প ছিল না? কিন্তু ওটা রেফার করছে না কেন বুঝতে পারি। Yes, Mr.
lordship, my learned senior friend's argument, my lord, if I have understood, my lord, revolves around my lord, if I have understood correctly, taking a cue from my learned senior friend, it has three limbs. One is that the vendor of his client was a non-agricultural tenant. Hence, non-agricultural tenancy was outside the purview of Estate Acquisition Act. Second, my lord, mutation already done, page 107. So why the exercise again? Thirdly, my lord, his vendor was enjoying the status of Boshot Proja. Boshot Proja comes within the classification of non-agricultural tenant. Therefore, automatically corollary is that he does not come in the domain of Estate Acquisition Act 1954. This is the three limbs. Three coordinate bench judgments are staring in my face, which my learned senior friend has cited rigorously. That is, my lord, one is Obhijit tie-up, another Adoma complex, and the other is Juhi Finales. Out of these three judgments cited by my learned senior friend, one went up to Honorable Supreme Court. That is Juhi Finales. Came back. I think the state government has preferred some review application, something like that. On that also, Lord, I should join my issue, because whether one-line rejection of Supreme Court SLP tantamounts to doctrine of merger or not that is also, I do have some points on that. Reported judgment is there. Now, my lord, my lord, respectful submission for lordship would be two parts. One is, my lord, the mutation part, and the other is the law part, whether non-agricultural tenant
is outside the purview. It is a long drawn battle. 3 coordinate bench judgments are staring in my face, but your lordship is also in coordinate bench. So that has to be, my lord, overcome by me. So firstly, my lord, let me address, my lord, on the point of mutation part. Before, my lord, going through that part, may I respectfully invite your lordships, my lord, to, my lord, the observations of the, my lord, learned tribunal. The learned tribunal, my lord, is my humble understanding, my lord, has made as many as 5 observations. May I respectfully invite your lordship to page 293. The relevant part where from, my lord, the observations of the learned tribunal, my lord, starts. My lord, page 293, lordship. Yeah. Sorry, my lord, 292, last paragraph onwards. It is admitted fact that the case land is situated at premises number 28, 28 by 2, 28 by 3, 28 by 4, 28 by 5, 28 by 6, 28 by 7, and 28 Howrah Road at Shalkia, comprising LR plot number 368/423 under LR Khatian number so and so. RS Khatian number so and so, corresponding to Howrah Municipal Corporation holding number 28 by 06 Shalkia Road under the Howrah Municipal Corporation ward number so and so. It is specifically asserted by the applicant that as a transfer of the case land in favor of the company was done prior to 9th October 1980. My lord, here may I respectfully pause for a moment. Why 9th October 1980? Because Section 3 of the Land Reforms Act has come into operation with effect on 9th September 1980. So until then, the non-agricultural tenant was, my lord, beyond the scope of estate acquisition. Virtually, in my humble understanding, wrong concept. So, lordship, the same does not come within the purview of vesting as per the provisions of West Bengal Estate Acquisition 1953. On the contrary, it is a specific case of the applicant in the way as well as in the affidavit in reply. The provisions of West Bengal Non-Agricultural Tenancy Act 1949 is applicable in his present case. Accordingly, on the ground mentioned above, the applicant has paid for mutating his name in the relevant ROR of the case land. The extent of now observation 1. What is the first observation? The extent of applicability of the West Bengal Non-Agricultural Tenancy Act 1949, as mentioned in Section 1 of the said Act, has been specified, wherein it has been specifically mentioned that the West Bengal Non-Agricultural Tenancy 1949 extends to whole of West Bengal except the area to which the provisions of the Kolkata Thika Tenancy Act 1949 applies. The applicability of Kolkata Thika Tenancy Act 1949, as mentioned in Section 1 of the said Act, has been specified, wherein it has been specifically mentioned that the Kolkata Thika Tenancy Act 1949 extends to Kolkata as defined in Clause 11 of Section 3 of Kolkata Municipal Act 1929 and to the municipality of Howrah. Accordingly, there is no doubt the provision of West Bengal Non-Agricultural Tenancy Act 1949 cannot be applicable within the area of Kolkata Municipal Corporation and Kolkata Municipal Corporation. The case land, as mentioned herein above, falls within the jurisdiction of Howrah Municipal Corporation, and accordingly, in terms of Section 1 of the West Bengal Non-Agricultural Tenancy Act 1949, the provision of West Bengal Non-Agricultural Tenancy cannot be applicable. So, jurisdictional issue of NAT is not applicable to Howrah district, land situated within Howrah district. This is one observation. I stand by it. Second observation, my lord, if I may respectfully, my lord, read out the next paragraph. The West Bengal Land Reforms Amendment Act 2007 came into force with effect from 15th May 2017, wherein there is a provision of amendment of Section 4B of the said Act. In Section 4B, subsection 2 was renumbered and inserted, wherein specific provision has been made as follows. My lord, it has quoted, my lord, the provision of this particular section. Now, my lord, if I may read out the sentence starts in view of such specific provision of the above Amendment Act, the applicant is undoubtedly the retainer of the land under Section 6(3) of WP West Bengal State Acquisition 1953 with effect from the state of vesting under the West Bengal State Acquisition Act, with effect from date of vesting under the West Bengal State Acquisition Act on and from 15th April 1955 or 14th April 1956, as the case may be, and from the date of such transfer, as the case may be in terms of proviso of Section 14(1),
excluding tea garden in terms of the case amended. The company was merely a retainer of the case land. Such retainer can transfer only such right or interest to his vendor which he had. The annexure D, that is title deed of the applicant, page 50 onwards of the OA is very much clear on that point at page 55, that the applicant was interested to purchase the case land from the first party company, Howrah Trading Company, on as is where is basis. The Howrah Trading Company cannot confer case land, cannot confer the applicant company better title than that he had. The fact remains that the case land is 6-3 land with effect from the date of vesting of West Bengal Estate Acquisition in 1953, and therefore the transferor company can transfer his right title interest in the case land which he had. So, my lord, so his vendor was a retainer. Retainer, since they retained land under Section 63 of the West Bengal Estate Acquisition in 1953, therefore retainer does not have the marketable right title interest to transfer the property. Therefore, that transfer itself is bad. Because 6-3 holder of a land is not a rayat, is clear from Section 4 of the Land Reforms Act. So the retainer of Section 60 land does not have a marketable right, title, or interest to transfer. Therefore, since your vendor did not had the right title interest, therefore the very deed itself is bad. My third observation, Milord, page Milord, internal page 7, Milord, 295. In support of his contention, the applicant has cited a decision reported in 2017 SEC Online Cal 5043, which the case land involved is situated at so and so. As per document filed by the state respondent, it appears that one review application is pending against the Milord. Lordship. Milord, this 5043 2017 SEC Online is mere juhi finales. This judgment which my learned senior friend, Milord, the Honorable Tribunal is referring to is juhi finales. So it went up to Supreme Court. Honorable Supreme Court, this was pleased to reject the special leave petition, and now it came back and the state has preferred one review application. Jui finales went up to Supreme Court. Leave was refused, reject lordship. So, Milord, this was as per document filed by the state respondent. It appears that one review application is pending against the said judgment cited above. Accordingly, unless the review application is disposed of, the said decision cannot be relied on. Accordingly, the above decision is not squarely applicable to the present case. The applicant cited another decision reported in so and so, in which the land comprised in tea garden is the subject matter. Accordingly, said land does not fall in the jurisdiction of KMC or HMC. Accordingly, the said decision is not also actually applicable to the present case. Now, Milord, observation 4, that is next paragraph. The applicant has shown on mutation certificate, vide annexure E of the key continuance of this proceeding. Direction was given to the applicant. Certified copy of the constituted proceeding of the state mutation case, but the applicant has failed to file certified copy of the mutation proceeding. Only he has filed certain documents, namely application for mutation, etc., which does not bear seal and signature of the office. Accordingly, the said unsigned documents are treated as unofficial and cannot be entertained. So this is a view, Milord, on page 101 of the petition. That is mutation certificate which was granted. This is a view expressed. In view of the last observation, in view of the above legal position, we have no hesitation to hold that being a retainer of the land, the company cannot have any jurisdiction to transfer title in favor of the transferee simply on the ground that the state of West Bengal is the actual owner of the land under Section 60. We do not find any infirmity in the order passed by the appellate authority under Section 54 of the West Bengal Land Reforms Act. Now, my lord, mutation aspect. My first limb of argument, my lord, mutation aspect. May I respectfully invite your lordship, my lord, to my lord, page my lord, 101. Milord, this is the mutation certificate, Milord, which the petitioner says that I was granted mutation. Certified that the name of Sri Nando Kishore so and so, daughter am so and so, possessing plot number so and so, Khatian number so and so, comprising with municipal holding number so and so, has duly been mutated to the. If this mutation,
name of law, co-traders. Who is Nando as a director, right? Yes, yes.
Lakshya Trading Links Private Limited, Nand
Yes,
Kishore
yes.
Chole, Director, Lordship. So this is what the petitioner says, that I was granted mutation long before in the year 2010. If you had been granted the mutation in the 2010, what was, may I pose this question to myself? Why did you go for effective mutation for the second time? The reason is very clear. Milord, why second mutation application? Kindly have a look at page 35. Milord, page 35 of the petition.
Yes.
Milord, page 35, Milord, may I respectfully invite your lordship to clause, Milord, Roman 8. The applicant states that for alteration in the mode of use of the said lands, mode of use, it approached the concerned respondent for obtaining permission for change of area, character, and use of land. It was verbally communicated by such respondent that it would not accept the mutation certificate issued in the year 2010, but the applicant should obtain certificate by way of online procedure. Thereafter, the respondent would issue a conversion certificate. So, my lord, second chance for mutation certificate was, in essence, to convert the land, mode of use, which is impermissible as contemplated under section 60.
No, he filed an application 4C1. Then you stated
No, lordship, my lord.
that if you want to get
4C,
4C1 conversion, change
4C conversion concept will not come in case of a land, my lord, which comes under section 6.3 of the Asset Acquisition Act. The moment there is mode of user, resumption will take place. This is a section 6.3 land, my lord. May I read out section 6.3, my lord? Kindly have a look at section 6.3 of Asset Acquisition Act.
একটু বের করে দিন।
Estate Acquisition Act. Yes. As and when they will approach for change of mode of use, then resumption question will arise.
Lordship, that is where I am on.
Land reforms.
My lord, before going straight to section 6.3, may I respectfully invite your lordship to section 6G. Section 6, clause G, subsection 1, clause G.
X1G.
Two clauses.
Subject to section
Yes.
6. Yes.
There are only two clauses in section 6, subsection 1, where it is not, retention is not automatic. One is clause F, subject to the provisions of the subsection 3, land comprising tea gardens or orchards or land used for the purpose of livestock breeding, poultry farming, or dairy. And G is subject to the provision of subsection 3, land comprised in mills, factories, and workshops. So it is subject, retention under section 6, subsection 1 is subject to section 6.3. If the land is comprised in mills, factories, or workshops, not only mills, factories and workshop, comprised in, Lordship has a particular meaning of comprised in. Mills, factories, workshops, land comprising in, Lordship. Comprise had a wider meaning, Lordship. Now may I take your Lordship to subsection 3. In the case of land comprised in tea gardens, mill, factory or workshop, the intermediary or where the land is held under lease, the lessee, shall be entitled to retain only so much of such land as, in the opinion of the state government, is required for the tea garden, mill, factory, workshop, as case may be. And the person holding under lease shall, for the purpose of assessment of compensation, be deemed to be an intermediary. So the land has to be held for the purpose of mill, factory, workshop, provided that the state government may, if it thinks fit so, to do after reviewing the circumstance of a case and after giving the intermediary or the lessee, as the case may be, an opportunity of being heard, revise any order made by it under the subsection, specifying the land which the intermediary or the lessee shall be entitled to retain, as being required by him for the tea garden. Now comes to resumption section, explanation 2. Explanation 2. For the removal of doubts, it is hereby declared that the expression revise any order mentioned in the proviso to the subsection shall, notwithstanding anything contained in any other law for the time being in force, or in any agreement or in any decree, judgment, decision, award of any court, tribunal, or other authority, include revision of an order of retention made under this subsection at any time after such order of retention so made, if the intermediary or the lessee, as the case may be, fails to use or ceases to use the whole or any part of the land for the purpose for which it has been retained, that is tea garden, mill, factory or workshop, as the case may be, by him, so as to resume such land as being surplus to his requirement by the state government. So the moment there is change of user other than factory, mill, workshop, the power of resumption can be invoked by the government of West Bengal. Next, juxtapose. May I respectfully invite your Lordship to chapter 2, of the Land Reforms Act. Section 4 of the Land Reforms Act.
Yes. Section 3 will not be a riot under sections 4.1.
So, the
6.1, one other part.
Lordship. So, he is not a riot. The retainer under section 6.3 land
will not be riot. No.
Wait.
Confused.
I'm trying to enter into the issue, please. I maybe have pennyworth knowledge in land, but I'm trying to assist the court. No, I'm not land. I'm trying to enter into, because the issues.
Okay.
Yes. So, if it is section 6.3 land, he is the retainer. If there is a change of user, the resumption can be invoked. So here, since there is a reflection of change of user, that is conversion, which your Lordship is borrowing the concept of section 4C of Land Reforms Act. But since the land relates to section 6.3 land, hence the explanation 2 of section 6.3 will come into play. He was trying to change the use. In this case, the resumption order has not yet been done. But in the other matters, I am told by a learned friend who are appearing that in those matters, resumption order has been issued. So, this is one part. Secondly, kindly have a look. My learned friend has referred to
Yes.
110. Milord 110, kindly have a look, Milord, at the order dated 14th March 2022.
Yes.
It was an application or mutation order under section 50. That is the order by the prescribed authority. It says 14 March 2022, notice duly served, service written filed with the case record. The petitioner, both the parties are present on call. The proceeding, the petitioner, both the parties filed hajira, which are made part of the proceeding. Heart petitioner, the petitioner claimed the land in a Mouza Golabadi, sheet number 12, number 1. The applicant applied for the following schedule of land. This is the application. What is the plot number? 395. Khatian 544 will be recorded in his favor by virtue of document. Examine the documents produced by produced by the petitioner, and the investigation report. It is found the applicant has obtained the suit property with a registered deed number transfer, instrument of transfer of following deed number so and so. Claimed plot does not match with the filed verification, does not match. Milord, why does not match? It says, Milord, may I respectfully invite your lordship, Milord, to Milord, page Milord 880, which is the deed of the petitioner. Milord, schedule to the deed, Milord, is Milord at page Milord 90. All that piece and parcel of definite demarcated area of Bastu land measuring about 5 kata 8 chitak 1 square feet be the same, little more or less, together with shade standing thereon measuring about 1380 square feet be the same, a little more or less. Hereinafter refer to the said property together right to use the common passage and so and so. Kindly comes, Milord, next page, Milord, land structures standing thereon or otherwise therein reputed to belong or apparent thereto holding Meswe so and so in the passage appertaining to, kindly sees the dag number, appertaining to LR dag number 368/423 under LR Khatian number 227 and 20230, revenue survey number so and so, so and so, so and so. Well, kindly match this, Milord, with the order. Why mismatch? Dag number 395 in the deed is LR dag 368/423. Did they ever go for any rectification of deed? That this particular dag number was mismatch word. Why the authority uses the word? Because the instrument on the basis of which was asking or praying or applying for mutation, the instrument shows a particular dag, that is LR dag 368/423, and this shows 395 plot number. That is a mismatch. So if it is if they want to say that this was a wrong quoting of the LR plot in our deed, then lordship knows they should have gone for rectification of deed, not shown anywhere.
Yes.
So that is the reason. Now, my lord, second part. So this is a mutation aspect of the matter. Now, my lord, I am on this point of law that non-agricultural tenant was outside the purview of West Bengal Estate Acquisition Act. My lord, section 4(5) of the Estate Acquisition Act came into force with effect on 15th April 1955. And chapter 6 of the Estate Acquisition Act came into force on and from 14th April 1956. So, my lord, of the Estate Acquisition Act. notification vesting estates and rights of intermediaries. The state government may from time to time by notification declare that with effect from the date mentioned in the notification, all estates and rights of every intermediary in each such state situated in any district or part of a specific notification shall vest in the state free from all encumbrances. My lord, here what vested with the state by operation of this particular act was estate. Definition of a state, my lord, lordship will not find in the Estate Acquisition Act. So, my lord, what does this act say? That if you don't find any definition of any word, although mentioned in the act, you have to take recourse to BT Act. My lord, kindly have a look, my lord, at section 2, my lord. Section 2, my lord. Clause B, clause P. The expressions used in this act and not otherwise defined have in relation to the areas to which the Bengal Tenancy Act 1885 applies.
Where you are reading?
My lord, section 2, my lord, I'm sorry, my lord. Section
Yes.
2, my lord, clause P, my lord.
Yes.
Yes, expression used in this meaning.
So, my lord,
from
section 4 was vesting the estate and rights of the intermediaries. But the definition of estate is not there in the Estate Acquisition Act, but it is there in BT Act. My lord, may I respectfully invite your lordship, what is the definition of state?
Have you bought the book? BT Act most probably not with us.
BT Act, I think it's their lordship. No, it's a newly common law has a house has come up with a new.
We have. Actually, I like it, but today. Yes, you say well,
Yes.
what was
My lord, BT Act, my lord, section 3, subsection, clause 4, my lord says, estate means land included under one entry.
Section 3, subclause 4.
Lordship. The definition clause. Estate means land included under one entry in any of the general register of revenue paying land and revenue free land, prepared and maintained under the law for the timing in force by the collector of a district, and includes government khash mahals and revenue free lands not entered in the register. So, my lord, the pith and substance is that when the term estate has been defined as all those revenue free lands and revenue paying lands under one register. It has not classified, the state definition has not classified lands with the agricultural land and non-agricultural land. Revenue paying land and revenue free land. Revenue free land, my lord, lordship knows Brahmottor, Devottor, Shivottor, Pirottor, Shiragi, Wakaf. Well, I'm sorry, may I hand over the.
Okay, we have got. Yes. Revenue paying land and revenue free land.
These are the only two classifications of state. Agricultural land, non-agricultural land, because, my lord, when this operation was going on, basically and essentially all the lands were agricultural. Mokorori Moroshi is the word, magic word here. I will show your lordship. Mokorori Moroshi is the word which is specifically used in the deed of the vendor of my learned friend.
That means
Mokorori Moroshi is a land which is incident to the agricultural land. I'll show you, lordship. Moroshi means generation of the generation. Mokoron means fixed rent.
Permanent.
So many Mokor, so lordship. So estate classification was revenue free land and revenue paying land. No other classification was there. Now, my lord, if I may respectfully invite your lordship to, my lord, Article 31A of the Constitution, because, my lord, so I shall cite a judgment of Supreme Court. This kind of, my lord, it's a constitution when judgment. This kind of, my lord, issue also came out from Kerala. This classification system, I am a non-agricultural tenant, therefore I do not come on. My lord, Supreme Court says that what happened regarding estate acquisition, agrarian reforms. The word agrarian reforms is wider than that of land reforms. So clubbing together concept of agrarian reforms, which took place under the Estate Acquisition Act, cannot be clubbed together with the Land Reforms Act.
Yes.
My lord, Article 31, my lord, capital A.
Yes.
Yes.
Lordship. My lord, Article 31A, my lord, which was inserted by, my lord, amendment, my lord, of 1951, has taken care of this acquisition concept. Kindly see me, it is a validation, it is giving validation to all the acquisition of estates laws. Notwithstanding anything contained in Article 13, no law providing for the acquisition by the state of any estate or of any rights therein, or the extinguishment or modification of any such rights, or I am skipping the rest of the portion. Now kindly comes to clause 2 of the article. In this article, the expression estate shall, in relation to any local area, have the same meaning as that expression or its local equivalent has in the existing law relating to land tenures in force in that area, and shall also include any Zagir, Inam, Mofi, or other grant, and in the states of Tamil Nadu and Kerala, any Jamnam right. Clause 2, any land held under Rayatari settlement. Clause 3 is applicable to us, my lord. Any land held or let for the purpose agricultural or for purposes ancillary thereto. May pause for a moment here, my lord. The ancillary thereto, including westland, forest land for including westland, forest land for pasture or sites of buildings and other structures occupied by cultivators of land, agricultural laborers, and village artisans. Clause B, my lord, the expression rights in relation to an estate shall include any rights vesting in a proprietor, sub-proprietor, under-proprietor, tenure holder, riot, under-riot, other intermediary, and any rights or privileges in respect of land revenue. Everything, lordship will find is who is an under-riot, who is a riot, who is a proprietor. All these definitions are there, my lord, in section 4 of the BT Act.
Yes.
My lord, may I take your lordship to the mother deed of the, my lord, vendor, of the petitioner? My lord, page, my lord, 45, my lord, of the petition.
But Mr. Gali, Article 13(1) is a saving of land. under the particulars. Very title of the article says, saving of laws providing for acquisition of estates. This argument of yours under Article 31 is regard to the saving of the
All
acts.
these statutes.
All these. Now, this argument which you're advancing, that we must read estates as defined in BT Act, that is an argument. Can you
No,
give
as
us
because
can you give us?
yes,
give us-
authority is there. Because Honorable Supreme Court has taken recourse to this, that the estate vested for agrarian reforms. And 1997 Supreme Court also says, all right, that you cannot invoke land reforms to disturb the acquisition or vesting which had already taken place under the estate acquisition law of the country. It's agrarian reforms, not land reform. After the completion of agrarian reforms came the land reforms. And land reform manual also says at place that vesting concept of land reforms is preceded by the vesting of Estate Acquisition Act. So we cannot jumble together one with the other. This particular argument, my lord, was never, my lord, argued. I may be, my lord, full trades in where angels, my lord, fear to trade. Because all the three judgments which are staring in my face today, Addoma, Vijay type, those similar, I don't find all these. So I may be a full trading in, my lord, where the angels fear to trade. But I thought over it after going through this judgment of the Supreme Court, the Constitution main judgment. This agrarian reform is trying to be disturbed by the Land Reforms Act. So, Lordship,
yes.
May I, my lord, respectfully invite your Lordship, my lord, to the mother deed, my lord, of page 45, the petition, Lordship.
Page,
my lord, 45 of the writ petition, Lordship. This is the mother deed. The deed of the vendor of the petitioner.
Yes.
This I'll just skip through, but I'll read some of the lines, my lord. This indenture made this 22nd day of September 1938 between the West Praise Shalkia Limited, a private company duly incorporated under the Indian Companies Act, having registered office at so and so as a vendor. The other one part, and Miller kindly says page 40, and Howler Trading Company Limited, a company limited by shares duly incorporated under the Indian companies and having its registered office at so and so, hereinafter refer to the purchaser. So Howler Trading Company purchased this particular piece of land from the Salkia place. This is the mother deed. Kindly have a look, my lord, of the mother deed. And where may I just read out some portions of this deed, my lord? Kindly, my lord, pardon me for taking, my lord, judicial hour, my lord. Of the other part, whereas the vendor is seized and possessed of and absolutely entitled to the lands, hereditament and premises comprised in the schedule hereunder, whether and delineated in the plan hereto, annexed, subject to the payment of rents and seizures payable in respect to the tenure. So it's a revenue paying land. May I pause for a moment, my lord? It was a revenue paying land, comes within the classification of state definition. Payable in respect of the tenure upon which the sums are respectively held, and all the jute press and other buildings erected and built thereon, or on fault thereof, and also the fixtures and fittings pertaining thereto. My lord, may I respectfully pause for a moment? So, my lord, it had a jute press and the buildings erected and building thereon. So, my lord, I was harping upon the word that section 6, subsection 3 says the word not building, not factory mill. It says lands comprised in factory mill. Comprise has a wider meaning, my lord, in the Oxford Dictionary. Lands comprised in. That is the word used. Not the only mill and factory. So,
yes.
So, my lord, recital of the deed says that there was some respectively held jute press and other buildings erected and built thereon, or on fault thereof, and also the fixtures and fittings. These were there. My lord,
fixture, my lord, kindly sees the last 4 lines from the bottom of the same page. Both hereby indefeasibly grant, convey, transfer, and assign unto the purchaser all these places and all these pieces and parcels of land belonging, being the premises number so and so, so and so, so and so, Howrah at Shalkia in the district of Howrah. So he is transferring the entire schedule delineated upon the so and so called upon, distinguished together with the dock, boulder, and press houses and all other erections and buildings of every kind, including store yards, bungalows, open sheds, jetties, darwans quarters, erected upon the said pieces and parcels of land and belonging thereto, and used or occupied therewith, and all yards, drains, paths, passages, waters, water causes. So all these he was transferring, and all the estate, right, title, interest, claimed or deemed whatsoever. So this is what he was transferring on the day. Kindly see the schedule. Millard at page 48. All these pieces and parcels of land premises number 28/2, all these pieces and parcels, Moroshi Mukurori lands, situate, lying, and premises number so and so, Howrah, appertaining to so and so, measuring and 10 biga, 14 kata, 9 chataks. So out of 10 biga, 14 kata, 9 chitaks, the petitioner purchased 5 kata, 8 chitaks. Kindly compare this schedule with the schedule at page 90, the present instrument of the petitioner. Mokorori Moroshi land, the instrument of my lord, 1938, becomes in the schedule of the petitioner of 2010, Bastu land.
No, what did you say that 10 bighas it was, and why did you refer us to page 90? What is the distinction?
Distinction is, my lord, kindly sees the
Page
classification
48.
here.
Page 48 is?
Page 48 is Moroshi Mokorori lands.
Yes. Of
Lordship,
10 bighas.
Total 10 bighas of land.
Huh.
It is a Mokorori Moroshi land. I am harping upon this particular phrase, my lord.
That you have argued already.
My lord,
Yes.
page 90, when he is purchasing the land in the year, my lord, I think 2010, the instrument is dated 2010. It becomes Bastu land, and he purchases only 5 kata, 8 chitaks.
Yes.
So, my lord, my respectful submission on this parent instrument, which I have referred to, my lord, at page, my lord,
But
45.
can we go into that issue, Mr. Ghalib? As regards the contents of the deed, the discrepancies which you are pointing out, whether in a proceeding, we are in judicial review of the tribunal order.
My lord,
can you ask us to go so deep as regards the very nature, character, and terms of the acquisition?
my lord, in respectful reply, my lord, to the query of the Honorable Court, my lord, may I say this, my lord? Since the Honorable Tribunal has been pleased to hold is a 6-3 land, my learned senior friend has taken a point that it cannot be regarded as 6-3 land. Why? Because I was a my predecessor was a non-agricultural tenant. I am outside the purview of Estate Acquisition Act. Cited 3 judgments. Since your lordship is also a coordinate bench, and the judgment cited are also a coordinate bench. So, my lord, this cannot be regarded as outside the purview of Estate Acquisition Act. This is what I'm trying to, my lord, assist your court, your lordship. I'm showing the parent judgment to show that it was a revenue paying land comprising 10 bighas.
Hmm.
It comes within the definition of a state as contemplated under the BT Act.
That you have argued, yes.
That is why, my lord, this is
Alright.
a subject matter.
Yes. Next.
Lordship, our reply to my lord, page kindly 101. My lord, kindly comes to 101, page 101 once, my lord.
Yes.
With regard to this document, my lord, our reply to this document, my lord, is at page, my lord, 220 of the petition. That is the pleading before the learned tribunal. 220. This was our reply.
Para 4.
Para 4, Lordship. I'm not reading it, I'm just placing, Lordship. This was our reply to this document.
What did you say?
With regard to averment made in paragraph 3 and 4 of the instant affidavit, this is submit that petitioner produced a mutation certificate dated 8th June 2010. But while producing the application form for mutation marked with the letter Y in the instant affidavit, it may be noted that nowhere there is any sign of receipt in such form. It is also pertinent to note that the petitioner claimed that the computer generated requisite receipts of fees for mutation annexed at page 10 of the instant affidavit is submitted. But upon perusing the document, it may be noted that such document is not related to mutation, but that of sale from the office of the ADSR Howrah. It is reiterated that the subject land comprised in a mill, factory, workshop of Howrah Trading Company, the predecessor in interest of the petitioner, which came under the purview of section 61G, read with section 63, and as such, the said land cannot be treated as an asset of the said company. Hence, in any sale of such land, nothing has been passed to the transferee, that is Lakshya Tradelinks Private Limited. The petition herein, since the said Howrah Trading Company Limited had no good or marketable title in respect of such land, that it may also be noted the miscellaneous receipt submitted in page 11 of the instant affidavit is also vague, without any proper stamp or signature. Also, the document submitted in page 12, it may be noted that the notice does not contain any date of issue or any signature of the official. The petitioner may be put to strict proof thereof for the instant document, since such act is vehemently despised. That it is pertinent to mention herein that the record of rights submitted in the affidavit dated 27 July 2023 will depict the recorded position of the instant suit land. I reserve my right to so answer.
Consider. Review is pending. আজকে আমরা যদি না যেহেতু it is an issue, এই ইস্যুটা তো খুব জীবন্ত ইস্যু, এটা নিয়ে তো তোমাকে তুমি জাজমেন্ট থেকে ডিস্টিংগুইশ করে আমরা বলতে পারি চেঞ্জ করে, কিন্তু রিভিউয়ের বেসিসে ঠিকই ডাজ নট অ্যাটেন্ড ফাইন্ডিং ডিসিশনটা যে হবে না সেটা না। এসএলপি ডিসমিস করেছে
ম্যানুয়াল বড় বইটা
না, ব্যাপার হচ্ছে তোমার
আপনার বড় বই আচ্ছা আপনার দেখি তো আমি নিলাম।
এসএলপি যেটা
রিজেক্ট করেছে ডক্টর অফ মার্চার অ্যাপ্লাই করে দুজনে রিভিউ হয়েছে
কোডাই ডিস্টিলারি
কোডাই ডিস্টিলারি
আমি তো সেটাই বুঝছি না কেন করছে চুপ করে আসছে। এটা আমি একবার দেখে আসবো। নিচে ডকুমেন্টটা চলে যাবে। Revise.
At any time, such a number of cases.
ডিটেনশন হবে হতে পারে জন্য ওই ক্যারেক্টারটা চেঞ্জ করে তুমি গভর্নমেন্ট এখন অ্যাকোয়ার করে সেটা ইজি আমি বুঝছি না ওরা কেন রেফার করছে আমি একটু পড়ে আসতে হবে ইয়েস
Yes.
So, Lordship, may place the judgment below with regard to Milord that estate Milord and where Milord this similar contentions of also Milord advanced Milord before the Honorable Supreme Court Milord AIR Milord that is Milord AIR 1962 Supreme Court.
No, Mr. Ghalib, you first come to Jui Finance and your argument as regards that which you have made, you attach that with the particular paragraph of the Jui Finance where it was may not be have been considered accordingly.
Juhi Finales Milord. Juhi Finales.
That was anyway.
Juhi Finales Milord. Regarding distinction of doctrine of major, Lordship wanted to hear that.
No.
May I place that judgment?
No, that is Kodai distillery.
Because, my lord, my
merger will not apply, yes.
Lordship.
SLP when dismissed, merger will not apply. Review can be filed, accepted.
And because of conflicting judgments of the Honorable Supreme Court, the last judgment of 2023, Volume 7, where I find that the Honorable Supreme Court, the concerned bench has sent it to larger bench.
Please. Which judgment you are showing?
This one with regard to the estate.
Yes.
Milord EIR 1962, Milord Supreme Court, Milord 694. Milord, kindly seize the issue, Milord. This petition it's a constitution bench judgment, Lordship. May I read paragraph 1, Milord? This petition has been filed under Article 32 of the Constitution and it seeks to challenge the validity of the Kerala Agrarian Relations Act 1960, hereinafter called the Act. The petitioner owns about 1250 acres of land in the Kerala state. These lands were originally situated within the erstwhile state of Cochin, which now forms part of the Kerala state. Out of the lands owned by the petitioner, hereby 900 acres are classified in the land records maintained by the state as Pandarakhya holding. Here we Boshot Proja this, and while the remaining lands are classified as Purabaka holdings. By this petition, the petitioner claims a declaration that the act is ultra vires and unconstitutional and prays for a writ of certiorari or other appropriate writ, order or direction against the respondent, the state of Kerala, restraining it from implementing the provisions of the Act. It appears that a notification has been issued by the respondent on February 15, 1961, directing the implementation of Section 1240 so and so. The petitioner contains a notification issued under the Act is also ultra vires, unconstitutional, and illegal, and as such he wants an appropriate writ or order to be issued quashing the said notification. That in brief is the nature of the reliefs claimed by the petitioner. Milord, paragraph, Milord, 26, my lord, straight, my lord, may I respectfully invite your lordship to. Eta one purla. 26. Having thus considered the background of the land tenures in Punjab and elsewhere, this court proceeded to consider the amplitude of the crucial words, any estate or of any rights therein, in Article 31A, Clause 1A. According to this decision, as the connotation of the term estate was different in different parts of the country, the expression estate described in Clause 2 of Article 31A has been so broadly defined as to cover all estates in the country and to cover all possible kinds of rights in estates, as shown by subclause B of Clause 2 of Article 31A. The expression rights in relation to an estate has been given an all-inclusive meaning comprising both what we have called, for the sake of brevity, the horizontal and vertical divisions of an estate. The provisions aforesaid of Article 31A bearing on the construction of the expression estate or rights in an estate have been deliberately made as wide as they could be in order to take all kinds of rights, quantitative and qualitative, in an area coextensive with an estate or only a portion thereof. Further, observations made in the judgment in regard to the effect of the addition of the word riots and under riots in Clause B may also be usefully quoted. The expression rights in relation to an estate again has been used in a very comprehensive sense of including not only the interest of proprietors or sub-proprietors, but also of lower grade tenants like riots or under riots. And then they added, by way of further emphasizing their intention, the expression other intermediary, thus clearly showing that the enumeration of intermediaries was only illustrative and not exhaustive. Thus, this decision shows that the amendments made by the Constitution First and Fourth Amendment Acts of 1951 and 1955 were intended to enable the state legislatures to undertake the task of agrarian reform with the object of abolishing intermediaries and establishing direct relationship between the state and tillers of the soil. And it is in that context that the word estate occurring in Clause 2 of Article 31A was construed by this court. What we have said about the decision in Medi is equally true about the decision in the case of Atmaram. The property which was held to be an estate was not an estate in the narrow sense for which the petitioner contends. In Sri, I read from 23 to 29. In Sri Madhava Pakistan state of Bombay, this court had to consider the case of the petitioners in Vidarbha who held lands under the state and paid land revenue for the said land thus held by them. The relevant provision of the Madhya Pradesh Land Revenue Code 1954 were examined, and it was held that though the word estate as such had not been employed by the state court, the equivalent of state had to be determined under Article 31A2A. And as a result of the provision of Section 145 and 46 of the Sixth Code, it was held the estates held by the petitioner satisfied the test of local equivalent of estate as contemplated by Article 31A. In state of Bihar versus Rameshwar Pratap Narayan Singh, this court had occasion to consider the scope and effect of the expression rights in relation to an estate used in Clause 2B, and it was held that in the circumstances and the particular setting in which the words riot and under riot were introduced into the definition, it must be held that the words or other intermediary occurring at the end do not qualify or color the meaning to be attached to the tenure newly added. It is in light of this decision that we must now proceed to examine the character of the properties with which the petitioner is concerned. As we have already seen, the petitioner owns about 900 acres of land, which are classified as Pandarabhaka holdings, and about 350 acres, which are described as Purabhaka holdings. In meeting the respondent's contention, these lands are an estate under Clause 2A of 31A, the petitioner has alleged that the Pandarabhaka tenure represents lands of which the state was in a position of the landlord, and whatever rights other person possessed were directly derived from the state. Of the several classes of Pandarabhaka tenure, the most common is the Bherampattam, and most of the petitioner's land falling under the Pandarabhaka tenure belong to this class.
The petitioner's case is that this liability to pay rent to the state calculated as a proportion of the gross yield of the properties, and so the lands held by the petitioner as tenant on the state cannot be said to be an estate under clause 2A. He is not an intermediary. He is not an intermediary between the state and the tiller of the soil, and so is outside the purview of clause 2A. It has also been alleged by the petitioner that his properties cannot be said to be an estate even in the sense of a local equivalent of the term estate, because there is no unified record of rights over the area in question. Each survey number is often divided into several sub numbers and representing holdings that do not often take in more than a few cents, has his own record of rights and separate assessment. It is for these reasons petitioner resists the application of clause 2A to these Pandarabhaka Verattam lands. No clear and specific plea has been expressly made by the petition in regard to Purabhaka lands. In that connection, the petitioner has, however, alleged that the Jamnam is another peculiar feature of the land system in Kerala, which it is not easy to define, since a good deal of ambiguity attaches to the term. However, he contends that the Jamnam right has to be understood in its limited and technical sense as taking within scope a particular form of landholding known as the Kanam tenancy. According to the petitioner, the Janam right included in clause 2A can take in only the rights and liabilities controlled the two tenancy act to which he has referred to. That is how the petitioner contends that Puriaka lands are also outside the purview of clause 2A. So they were an attempt to bring these lands that he was not an intermediary. So it should be outside the purview of estate. So this judgment was, my lord, delivered through the prism of the word estate. Now kindly see, my lord, paragraph 33 to 35. It would thus be seen that under clause 13, the person holding land on the Pandarabhaka Virappan tenure is not a tenant. He is given the proprietary right in the soil itself, subject, of course, to the rights as to metals and minerals reserved in favor of the state. Indeed, the whole scheme of the new proclamation appears to be to change the character of the possession of the Pandarabhaka Viratna tenure holder from that of a tenant into that of a proprietor holder. It is true that he is made liable to pay half of the net produce, and that may appear to be little too high, but the measure. So Miller kindly sees the conclusion of paragraph 33. Therefore, we are inclined to hold that the Pandarabhaka Virattam can be regarded as a local equivalent of an estate under clause 2A of 31A. And Milord, 33, 34, and 35. Kindly see 35, Milord, say the result is that the lands held by the petitioner are an estate under clause 2A. And so the act, insofar as it operates against the holdings of the petition, is protected under 31A. And so it is not open to the petitioner to challenge its validity on the ground of so and so. So, Milord, here, Milord, the estate definition, Milord, was, Milord, taken a research that whether he is, Milord, claiming that I am not an intermediary, I am a tenant of certain land. So I should be brought outside the purview of the word tenant as is used in the Constitution. Honorable Supreme Court says no. Estate term is wider, wider, and wider. So, Milord, here, Milord, what I am harping upon is section 4 uses the word estate. So, estate, we get a reflection in BT Act. BT Act gives the definition: the revenue free land, revenue paying land. So far as the parent deed of Howrah Trading is concerned, it was a revenue paying land. It was a factory land comprising of different structures. So, Milord, it is very much a subject matter of Estate Acquisition Act. Hence, Milord, as a consequence, section 6(3) land comes into play. Next judgment, Milord, 1997 5 SCC. Yes. Milord, PH Milord, Milord 3-1, Milord 7. 317. Milord, this is 1997 5 SCC 317. Milord, paragraphs, Milord, 3. paragraph 3.
Three for fact. Opposition. Three for fact. Oh.
3 for fact. 4 and 5.
Yes. Yes, yes.
Sorry. No, 3, 5, and 6.
Yes.
The notif may read out 3.
What is the proposition?
Proposition is, my lord, kindly sees paragraph 6. It is then contended that by operation of section 3A of the West Bengal Land Reforms and 1956, the non-agricultural tenant does not stand vested. We find no force in the contention. What is vested under section 3A of the land reforms is the tenancy right in a non-agricultural land and not the proprietary right.
Oh, Arun Kumar Bose. Yes.
Proprietary rights have been long abolished by operation of section 4.1.
Yes.
It is then contended that direction may be given to the state government to pay compensation so and so. So, my lord, what we are on, my lord, that proprietary right which had gone by operation of State Acquisition Act while the agrarian reforms was in on. There, my lord, and my lord, Article 31A also takes care of proprietor, sub-proprietor who are related to a state.
Yes. Next judgment.
Nine 4, my lord, SCC.
2009.
2009 4 SCC, my lord. Page 453. It's a Ratnagiri judgment.
Paragraph?
My lord, 9 4 SCC. Paragraphs 10, 11, 12, 14, 16.
Proposition? Oh, Ratnagiri.
A part of this judgment was against us in paragraph 18. That's why the explanation 2 was amended thereafter. Lordship will find that there was an amendment to section 11, section 2. After Ratnagiri, the act was amended to take care of that portion that many things have changed. Now you are revising the order and taking by the property since it is 6-3 land. If this is the situation, then nothing will change. What was mill there at that time, you are saying it has to be continued as a mill. So that's the explanation 2 was added subsequently. The effect of Ratnagiri is that we have brought in explanation 2. Kindly see the amendment date of explanation 2 of. Kindly see, my lord. Explanation 2 was brought into effect on 9th November 2010. This judgment was of 24th February 2009.
Yes.
My lord, a coordinate bench judgment of our honorable court, my lord.
Yes, what you're saying?
A coordinate bench judgment of our honorable court, my lord, 2023 SEC online cal.
That is the one cited by Mr.
No. It is 3568.
This is 2023.
Lord, I am handing over, Lord. 2023 SEC online cal. My lord, 3568. It is Jitendra Investment Private Limited. Paragraphs 2, 3, 22 to 25, Justice Boshak and Sabarashi. 22 to 25 and 27. Proposition is made, the Lordship, that you are a subsequent purchaser. Even if you are running a mill, tenant considered, but your estate remains vested under the Estate Acquisition Act. It says, my lord. Paragraph 23 and 24 specifically it says.
Jui finance was considered. This was on 27 September
Lordship.
23.
Yes, my lord. Jui finance, my lord, paragraph 9. Para 9, it says it has been, it was relied upon by the petitioner, Lordship. No, yes. Now, Lordship, last textbook I would like to refer to, my lord, respectfully, my lord. LR manual is also very much clear. My lord, LR manual, my lord, chapter 7. Rule, my lord, 100. My lord, rule 100 of the manual, my lord, says, my lord, provisions imposing ceiling on land holding are embodied in chapter 2 and chapter 6 of the West Bengal Estate Acquisition 1953 and in chapter 2B of the West Bengal Land Reforms Act 1955. Determination of ceiling under the West Bengal Land Reforms Act shall ordinarily be preceded by determination of ceiling under West Bengal Estate Acquisition. So, my lord, ceiling concept which is brought by the Land Reforms Act, my lord, cannot be clubbed together the concept of, my lord, Estate Acquisition Act. So, what had vested?
Yes.
My lord, what had vested under Estate Acquisition Act, my lord, cannot be brought back to life by invoking, my lord, Land Reforms Act. I was a non-agricultural tenant. In order to be a non-agricultural tenant, you had to hold non-agricultural land. But definition of estate brings about only two classification, revenue free and revenue paying. Now, my lord, doctrine of merger, if I may, my lord, regarding the finales, went, my lord. Now, my lord, may I distinguish these three judgments which my learned senior friend, my lord, had cited.
Mr. Galib, come, we are fixing another date. Finish it up because we have another Andaman fixed matter.
Fine, Mr. Orul is there. I find Mr. Orul is there waiting.
I will just distinguish, my lord. I'll just take 10 minutes. Next time, my lord, I'll just distinguish the judgments and doctrine of merger.
You finish it up. That will be about 15 minutes. Mr. Basu, any reply, you finish it.
When my lord is fixing.
Let us see when can we fix.
The argument which Mr. Galib advanced, my lord, I have to look into these things.
Tell us
what is the effects of that.
The tentative bolo.
Judgment of what is it? Citation and nature.
We are keeping it on 20th March at 2 p.m.
Same as to item number 18 and 19.
Same.
All those matters will appear. Oita shuddu, oita oi nonomor na.
In motor, who are the in motor? In motor will also on that.
Now the thing is, in
My
this
lord,
matter,
the new ambassador card. My lord has seen the new ambassador card. New ambassador card, my lord has seen. Just launched. Hinmotor reminds me that. Hinmotor is famous for that.
No, though they are claiming that our matter is to some extent different.
we have extensive.
My lord will be hearing
Mr.
one after another.
Galib Lanet, senior government advocate, establish the matter for further consideration on 20th March as fixed at 2 p.m. হ্যাঁ, যেরকম করেছিল ওরকমই থাকবে, অর্ডার করার দরকার নেই। And
তোর আবার কি হলো পরেরটা তো
Also fixing the next matter.
yes, yes.
That matter, I'm led by Mr.
Huh?
I'm led by Mr. Patel.
ask him to be present on that and to finish off.
Get some difficult. That's 21st.
No. What I'm submitting, my lord.
No, I will complete on that. There are.
No, the next
We will
matter,
forget unless we keep it on.
what I'm submitting, my lord, next matter, kindly hear me first, because it is not identical. One of the point is similar, but it is not identical.
Let us see, come on.
Grateful to your lordships.
এটা নয় ও পরেরটা বলছি। This type of matter, it is continuous and is there, it is for my lord also effective. After a long gap, again you have to recapitulate. So pressure is such, I cannot press also. You will be benefited. No. Pressure is of the court. Great.
ওনাদের অ্যাপিয়ারেন্স দিয়ে দিচ্ছ। আন্দামানের মামলাটা
হ্যাঁ
লিস্টটা বের করেছো কি? কবে থেকে হচ্ছে? নেক্সট কিন্তু 10 তারিখ থেকে। সেটাই ভাবছি 11 তারিখ একটা মেরিটে শুনতে চাইছি, প্রাইমারি ফাইন্ডিং দিয়ে দিলে দেখি কি বলি।
No, the urgency to move the application along with the memo, lordship, it's very limited. The Tahsildar Port Blair for the second time issued an eviction order, and that order was passed pursuant to an order of the division bench.
The defect, you have not put your signature behind the wakalatnama. You are on record.
We both are on record. We both are on record.
Wakalatnama you have ডিফেক্ট এখানেই করে বলার না পিছনে।
You accept.
Remove the defect.
I'm grateful. I'll serve the copy, lordship. I haven't given and put notice to Ms. Babita also. Pursuant to
Yes,
the
I am appearing, my lord.
yes. Correct, my lord. What has happened?
I am appearing on behalf of the official respondents, my lord, 1, 2, and 3, my lord.
My lord, I am appearing respondent number 4. I have not received any copy, my lord.
It's being
We have also just now received.
My lord, only page 43 of my stay application.
Now wait, madam, can we, because the circuit commences on 10th of 10th. So till 10th of March, if you restrain your hands, in that case, we will send it to the regular bench. Otherwise, if we hear on merits, we have to give a prima facie opinion. We can simply adjourn it till the 11th of March, subject to the convenience of the court. The matter will be listed on that date.
My lord, contempt.
On 7th, the contempt application is fixed, my lord. On
On
7th of this month.
So you take an adjournment on that date.
Complaints is to be filed by the Tahsildar
My
on
lord, we
7th.
have to comply the order passed by the division bench, single bench, my lord.
Division bench.
Division bench. The eviction order.
Tahsildar passed the eviction order, which have challenged the writ court. No interim protection was granted, so this appeal has been taken out.
So, my lord, we have to file our compliance report on 7th of March, my lord.
Passed the order, which have challenged the writ court, against which this appeal has been taken out. Now the division bench.
What happened?
What has happened in the first round?
Take your mic, otherwise they won't be able to hear your arguments.
The first round, my lord, the Tahsildar passed the eviction order as against my client as well as against the private respondent herein. The private respondent challenged that eviction order in a writ court. The writ court, on the ground of violation of principle of natural justice, set aside the order. By the time the order could be set aside, the private respondent was removed from the subject land. It's a government revenue land. Feeling aggrieved, the private respondent approached a division bench, seeking a status quo ante, because by the time the writ petition was allowed, he was removed from the land in question based on the eviction order. The division bench did not consider the prayer. Simply, the division bench relegated the matter to the Tahsildar to take a decision with the due process of law. No, Tahsildar revives.
The Tahsildar's order was set aside.
Yes, the first round, the order was set aside. It was relegated back. The division bench said, take decision in accordance with law. But I have been put in notice. A date was fixed. Unilaterally, date was preponed. Date was preponed by the Tahsildar. The reason behind was...
No, in that you were not the person.
Not,
that was the private response.
The eviction order was against the private response. There was some finding as against my client.
Anup Singh.
There was some finding against me.
You were appearing for whom?
Anup Singh.
So who was the first writ petitioner?
Private respondent herein.
What is his name?
It's VKM Mohammed Biskin. I'll show that order also.
Very good. Then what happened? Then you filed a fresh writ petition.
Fresh writ petition challenging the order of the Tahsildar for the second time, whereby my eviction has been directed on 5th of this month.
But how you are placed with the private respondent?
Because the first order
pertaining to the same land.
Same land. The Tahsil.
You were the joint possessors.
No, I am having a separate property. The Tahsildar says that adjacent to my property, I have encroached a government land. In the same tune, Tahsildar says even private respondents have also encroached a government land.
So that has no connection with the earlier.
But the eviction order is staring my face. Tahsildar now says, because he was acting in terms of the division bench order, which says that you have to take a decision with due process of law. Tahsildar passed an order without giving a notice, no hearing. The adverse report was relied upon, no copy
that
was
is in the private respondents
against me. Now the order is standing against me, my lord. I'll show that order.
So there was only one order pertaining to both of you.
Both of you. But so far as first order was concerned, no eviction was directed against me. Only finding was there of the Tahsildar.
So you did not go up in appeal?
No, I hadn't approached Lordship.
So against that, private respondent went up in appeal. Appeal court set aside, relegated the matter.
Single bench set aside, my lord. Against that, private respondent again approached before this court, seeking status quo ante, because by the time the order was set aside, he was removed from on the basis of an eviction order. The division bench said nothing, no status quo ante. But the Tahsildar was directed to take a decision in the line of the Honorable Senior Judge order with due process of law.
Then a decision has been
Yes,
taken.
that have challenged in the writ which is pending.
No, in that decision you were not heard.
I was given a notice. A date was fixed. The date was preponed unilaterally.
You had no
notice first.
No notice
No
of
notice.
preponement.
No. No. Secondly,
very good. Now this order has been challenged in a writ petition.
It's pending.
That writ petition interim order was refused.
Refused. Certain
Against that you have
come up with this appeal, intra-court appeal.
Now contempt is in connection with which order?
With the same division bench order, because the private respondent says, because there was a deadline given to the Tahsildar to conclude the proceeding 45 days. Since it was not done, the contempt was initiated.
My lord, it is at page 46, my lord. May kindly come to page 46.
The moment Tahsildar received the contempt notice, he passed the order by preponing the date.
Very good. Now the contempt is appearing before the circuit bench.
Division bench, my lordship.
Division.
Yes.
So that cannot be heard until the circuit bench.
No, my lord. VC through VC.
My lord.
Through VC, my lord.
Yes, my lord. Lordship's eviction order is under challenge, and it is standing in my face. And I have challenged the legality of the order on certain recognized grounds. Till Lordship, my writ is decided. Simply sit the writ court directed for exchange of affidavit. On the first order, I'll just show that order first, my lord. The eviction order I'll show. Subject matter of the pending writ, page 43.
No. What did the appeal court select?
I'll take one last to that.
Page 46, my lord.
Yes. With the Honorable my lord, division bench. No, it's contempt. 46 is contempt. I'll show the division bench order.
Division bench order, my lord. Page 38, my lord. My lord, page 38.
Yes, page 40 may kindly be seen. Page 40.
Starts from page 38.
It has demolition is 5th March.
5th March. I'll show that note. Not paragraph, page 40, paragraph 12 may kindly be seen. Page 40, paragraph 12. Kindly see once, page 40, paragraph 12. Once the order of the division bench. In the above, sir.
How can we stay the coordinate bench order?
No, it's not question of saying. No, sir, pursuant to the order of the division bench, Tahsildar have already taken a decision. So, which I have challenged in accordance with law. Not kindly see page 41. Page 41.
Where is that pursuant to this order of 19th February?
Yes, yes, I'll show that. That is the order which I have challenged before the writ court at page 43. 43. The order of the Tahsildar. Kindly see page 43, first line. It's whereas an order dated 7th November 2024 of the division bench has been passed by the Honorable High Court at Calcutta Circuit Bench at Port Blair, wherein the operative of the order is that insofar as the land of the private respondent is concerned by an order dated 18th March 2024, the Tahsildar Port Blair has found that Sri Anup Singh, son of late Sitaram, is an unauthorized occupation of an area of 398 square meter of survey number 167 and 51 square meter of survey number 168 respectively. The relevant portion of the letter dated 18 March 2024 is set out hereunder. The quantum is recorded. In the above circumstances, this court directed the Tahsildar Port Blair to take steps to remove unauthorized encroachment, demolish construction thereon after due process of law. That's the catch. It is expected that the proceeding against the private respondent is completed by Tahsildar within 45 days from the date. So this order was passed beyond 45 days. So the contempt came to be filed, which is pending. The contempt which the private respondent has taken out, it's said that the Tahsildar has passed this order. He ought to have passed the order, but it was not passed within 45 days. So the Tahsildar immediately passed this order. Now kindly see the order in contempt. I'll show that also, where this has been directed. Now it says with due process of law. Once the matter is relegated to the Tahsildar, he has to pass order in accordance with the local regulation which is prevailing. And he has passed the order. Regulation 202.
Now they are going to place this order before the division bench on 7th.
Yes, showing that it has been complied with.
Then how, what protection you are wanting from us?
Page
today?
45 may kindly be seen, sir. Page 45. Page 45. Not kindly see last but one paragraph. Now therefore, it is addressed to Anup Singh. Now therefore, in an exercise of power vested upon me under section 202 of Andaman and Nicobar Islands, Land Revenue and Land Reforms Regulation 1966, I do hereby direct Sri Anup Singh, son of late Sitaram, to vacate / remove the said unauthorized occupation committed over an area of 398 hectares of land bearing survey number 167 situated Hado village recorded as government revenue land on or before 4th of March 2025, failing which the Revenue Inspector Circle number 2 shall vacate / remove it by using government machinery with the assistance of police.
So you are agreed by this portion.
The order writ petition has been filed, it's pending. Against this order, the writ petition has been taken out during the last circuit.
Yes.
I have paid for an interim protection. The records were called for. Then, Lordship, simply a direction to exchange an affidavit was passed. Now this order is staring in my face.
Now, challenging this order, you came to the writ court.
I'll show my
writ court refused injunction.
Yes,
Against that order, you have
yes,
come.
Yes.
Now, your portion of the land is 167 survey number.
My land, I'll show my land.
Now, what is the portion of the land of the other one, private
respondent? I'll show that.
Same plot.
Same plot, same survey number. Quantum is different.
So, in respect of the same plot, division bench has said demolish it by 5.
My lord.
So, if we pass this order, how can we differ with the
My point is that nowhere division bench said that it has to be passed blindly. It said due process of law, this has to be passed. Tahsildar, with due process of law, has passed the order, 202 order, which I have challenged the writ court. And my lord, see the language of 202. I have given a notice to the Tahsildar. In terms of regulation 202, if a notice is given to the Tahsildar, then he would, for filing a civil suit, he would stay his hand for a period of 3 months. And if a suit is filed, automatic stay till disposal of suit.
Then why did the learned single judge did not give you the injunction?
My lord, kindly come to the order of the single judge. My lord, I'll show my writ petition, which is pending writ petition from 47A. 47A of the CAN. My lord, kindly see the order of the Tahsildar, which I have just referred to, has been challenged. 47A is the writ petition.
No, we are wanting to know, suppose if we pass any interim order in your favor, that will be contrary to our coordinate bench judgment.
No, subject to what my law says. No, the division bench said it has to be with the due process for law. I want to show that paragraph of the division bench order.
So,
my lord, kindly come to that. It's at page Just one second. Page
46.
38, 38, 38, and the relevant page is page 40. So kindly see paragraph 12. Page 40, paragraph 12. In this above circumstances, this court directs the Tahsildar Port Blair to take steps to remove the unauthorized encroachment and demolish construction thereon after due process of law. What is due process of law, Lordship?
Achha, very good. Then after this order, the order impugned was passed.
Yes.
That is you showed
I've
us.
just shown.
That is page.
Page is not, it's page 43.
So in this order, demolition not only in respect of the private respondent as well as against you.
My lord.
Now, private respondent demolition, what did he say? Order 7th. Now this order.
Now, so far as private respondent occupation is concerned, that has been removed on the date of first order of the Tahsildar. First order.
That was when?
I'll show by His Lordship Honorable Justice Prashanth Biswas. I'll show that order. At page 34. Page 34. Page 34. Page 34.
34.
34. This is by the private respondent in the present appeal. Lord, kindly see the order which has been challenged. It's 10th April 2024 order of the Tahsildar. May I place it, my lord?
No, no. What happened? This was. He challenged that order.
That order, it was set aside on the ground of violation of principle of natural justice, and the matter was relegated to the Tahsildar.
Then what happened?
Then, my lordship, the private respondent approached the division bench because the
he has already been removed.
For status quo ante.
So status
no
quo.
status quo ante was granted. Tahsildar was simply directed, you take decision with the due process of law, but within 45 days. But when it was not done, the private respondent filed the contempt which is pending. But due process of law, the Tahsildar passed the order, which I have challenged in the writ court. It's pending. It's taking several legal grounds. One of such.
Yes, madam. What do you have to say?
My lord, may kindly come to the. My lord, may kindly come to page 46, my lord. It's an order passed in the contempt application, my lord.
Yes.
My lord, may I read, my lord? The affidavit of compliance has been filed by the alleged contender in court today. This court had directed demolition of the unauthorized construction by the Tahsildar on 7th November 2024 within 45 days. The Tahsildar appears to have proceeded, albeit with delay, and issued an order on 15th February 2025 directing the private respondent to demolish the unauthorized construction of his own. Since the concerned statute has been followed by the Tahsildar and demolition has been ordered, failing which demolition shall be carried out by the Tahsildar's office with police assistant on 5th March 2025. Next page, my lord. An additional report shall be filed by the Tahsildar Port Blair on the adjourned date. The Tahsildar Port Blair shall be virtually present before this court on the adjourned date. Leave is granted to the petitioner applicant to file an objection to the affidavit of purported compliance filed by the Tahsildar. It is submitted by Mr. Prasanth, learned counsel for the petitioner applicant, that the order dated 15th February 2025 passed by the Sri Vijayapuram Tahsildar Port Blair does not indicate compliance of the area of 51 square meter in survey number 168 being a single-storied RCC building. The order of demolition as directed herein above shall cover item number 2 of the order dated 15th February 2025 passed by the Tahsildar Port Blair. Let this matter on 7th March 2025 at 2 p.m. So, my lord, we have to file a compliance report by 7th March 2025 at 2 p.m., my lord. So, there is already an order passed in the contempt application, my lord.
You are not a party to that contempt.
No, I have not been put in notice, my lord. I have not been put in notice. The day when this order was passed, I was not put in notice.
No, no, you are the owner or holder of occupant of.
My lord, before passing of this eviction order, my lord, notices were sent to the parties, my lord, and the petitioner herein has received the notice.
And 162 0.22 hectares.
My lord.
but you are also occupying the 161/1.
This is what Tahsildar says.
It is a government land.
It's a admittedly, Lordship.
And comprising an area of 0.0051 hectare.
My lord.
At the time of demarcation, it was detected that you are in occupation of this portion.
My lord.
My lord.
Now, 43 says,
my lord,
come to last but next paragraph, last. And whereas in pursuant to the direction of the Honorable Court, ample opportunity provided to both the parties.
My lord.
That means opportunity was given to you following the due process of law.
No, my lord, due process of law, it's naturally justice is one of the species, my lordship. There are other things to be added to. My lord, kindly see page 42 once, the notice, page, first page. My lord is on page 43. My lord, kindly see page 42. It is a notice giving me the date as 18/2. My lord, kindly see last but one paragraph. Tahsildar put me notice. And whereas in pursuant to the direction of the Honorable High Court, the demarcation of land has already been completed. Hence, the matter will be heard on 18/2/2025. The impugned order passed on 15/2/2025, my lord. I'm supposed to appear before the Tahsildar on this day. I have to place my case. I have to seek for adverse material so that I can.
My lord, we have issued another notice on 12th February 2025 stating that the matter has been is fixed on 15/2, my lord. Which he has received it. Which he has received.
Have you served that upon him?
Yes, before the single bench, my lord, we have, yes, it was served, my lord, and the record was produced. If my lord comes to this single bench order, my lord, it is there. My lord, I'm coming to that.
So many records. If the record was simply seen.
At the time of demarcation, he was present.
Yes, he was present, my lord. He has not annexed that notice, my lord. It's dated 12th February 2025, where his signature is there. He appeared, my lord, on 15th.
Was the ordered impugned what?
My lord, it's page 43. Page 43. I have been shown as a squatter of a government revenue land along with my recorded land. Lord, this order was passed under regulation 202. Lord, kindly consider this. Under the regulation 202, if a notice is given, Lord, kindly see the regulation 2028. Simply sit a notice informing Tahsildar that I want to file a suit. Stay. If a suit is filed, automatic stay till disposal of suit. Kindly have a look to the regulation once. I have issued a notice also. With the due process of law means everything includes. Lordship, not only principle of natural justice. I have taken this point in the writ petition. Not kindly see the regulation 202.
What did the learned single judge say? You must have argued.
On the first day, the record was on the first day. On the second day, simply affidavit exchange. That's all, my lord.
My lord, page 11. It starts from page 11, my lord.
Regulation 202.
He has produced the records, my lord, that shows that he has received the notice, my lord.
Coming back.
Page 40 of the regulation. The order one which I have challenged before the writ court is under 2021. Page 40, the regulation 1940. My lord. Rules, there are two parts. It's the rules and regulation. But not kindly see the first part of the book. Page 40, regulation part. 66 regulation.
They bring it out for us.
May I flag it?
Yes, page 40.
Not page regulation 202 may kindly be seen, Lord. If any person who unauthorizedly takes or remain in possession of any occupied land or abadi may be summarily ejected by the order of Tahsildar, and any crops which may be standing on the land, and any building or other works which he may have constructed thereon, if not removed by him within such time as the Tahsildar may fix, shall liable to be forfeiture. Well, I'll take Molos to 202, 7 and 8 at page 41. If such order is passed, what is the recourse? 241. No order made under subsection 1 shall prevent any person from establishing his right in a civil court. 8. If notice of an intention to institute a suit is delivered to the Tahsildar, he shall desist from carrying out his order under subsection 1 for a period of 3 months. And if such suit is filed within such period, he shall stay his proceeding pending the decision of the civil suit. That's one of the ground I've taken in the writ petition, my lord. Lord, I can show from the writ petition. To challenge the impugned order, because no breathing time was granted, I filed the writ. Notice was served then. Kindly consider that, my lord. It's a ipso facto stay, my lord. If I file a suit, if I issue a notice, for 3 months, the eviction order will be kept in.
That was not your argument, sir. Before the writ court. Mr. Jaipal, your argument was notice preponed. I did not get any opportunity.
My lord, I may be permitted to submit, my lord.
Lord, kindly appreciate one thing.
My lord, kindly allow me to submit, my lord, only for 5 minutes.
Third, we will come back to you.
Lord,
Yes,
kindly, Lord, kindly see page 23. This is my land. It's in my name. I have obtained a sanction plan. Based on the eviction order, they want to.
That is not under review. You are challenging, you are saying that it has been passed in hot haste, preponing the date of hearing.
My lord.
So that point, record was called for, your injunction was refused. That refusal was on 25th February 2020.
27th February.
25th February.
25th record was called for. 27th was the date when the
order was passed on 25th February.
No, 27th.
How?
Page 53. Page 53. 25th order is simplicity and order calling for the record.
53.
Page 53. It was the Tahsildar record was called for.
Page 53.
Page 53.
Oh, 27th.
Yes, my lord.
Yeah, give us.
My lord, some protection for a limited period, my lord.
Compliance করে notice report দিতে হবে। Compliance করতে হলে তো demolish করতে হবে।
demolish করতে হবে। আরে 7 তারিখে কি হচ্ছে? 7 মানে হচ্ছে Actually, we are one of the subjects that we are going to stay of the operation of a coordinator.
The division bench says with due, that's the catch, my lord. I could have understand that these two words were not there. Due process of law includes everything.
Mr.
My lord, kindly appreciate that, my lord.
A division bench
brought to the notice.
Kindly have a look. I can at the cost. I can at the cost of repetition.
I had a right to approach the civil suit, so court. Otherwise, division bench would not fix the shortest date.
The reason why in the contempt order was passed was that the Tahsildar could not pass the order within 45 days. That was the sole reason. No, kindly appreciate. Nowhere this division bench said that it has to be passed unilaterally. It has to be with due process of law. That has been duly recorded. And Lord knows principle of natural justice is one of the
process of law that was followed according to them.
Principle of natural justice
Now,
is one of the
she is right. She has to file the compliance report.
Not.
Now, if she doesn't file, she has to say, because of this order, we have not been able to comply.
Compliance order showing the order passed by the Tahsildar, which have challenged the writ court. That would be the action, my lord. My lord knows that. The Tahsildar has to file a compliance showing that 15th February 2024 order has been passed by the Tahsildar.
Where is the page 46? Where is the earlier order of the division 7th November?
I'll show that one. At page 38 and 40. Paragraph 12 may kindly be seen, my lord.
We would have to interpret an order passed by a coordinator.
Due process, no, I'm on that. I could have understand there was no due process of law language embodied by the division bench. Straight away pass an order, evict me. I could have understand. When it comes to the due process of law include everything, Lordship, in accordance with law. Notice has to be given. If an adverse material is collected against me, I'm entitled to rebut it. It's a species of theory of non-disclosure, Lord. If it's not complied with, it can't be said that it is due process of law. The entire decision-making process would be bad.
Now the order of demolition is the one which 15th of February.
Yes, my lord. 15th of February 2025. I'll show that page.
And 7th, pursuant to 7th November order,
my lord,
this order was passed
by the
on
Tahsildar.
15th February.
Yes, by the Tahsildar. Now this order has to be placed before the contempt court showing that compliance has been done because the Tahsildar was directed to take a decision.
So it was said you complete it within 45 days.
45 days.
From 7th November.
My lord.
They did not comply with
Yes, my lord.
They filed after 45
Yes.
days. In the meantime, contempt.
Yes, my lord. That is the reason, my lord, why the order came to be passed. Lord, there are other grounds to challenge this order. I have taken in the writ petition. That would be subject matter. But if the order is given effect to, my lord, the entire writ petition would go. The points which I have raised to question the order, the Tahsildar would evaporate. These are the one which I have shown just now, 2028, my lord. This is a protection given by the law to me, my lord.
Tested by the division bench and in that
For a limited period, my lordship, till first day of the circuit.
his mind on appeal till that date.
একটু বলেছে মাথা কি additional report be filed.
Preliminary examination shall be carried out by the Tahsildar office which police assistant on it. Where you are not private
Party.
respondent.
I was not been put in notice, no. It's simply Tahsildar and the private respondent was a party at page 46, contempt application. No notice, nothing was given to me.
And item number 2 was the subject matter of the main petition, main proceedings, main appeal.
My lord.
Item number 2 means
1 and 2, my lord.
it is construed that page 44.
My lord.
Page 44, item number.
My lord, page 44.
And
Yes, yes.
Survey number 168 by 1, that is the 0051 hectares which government land.
Yes.
It is the answer number.
My lord.
Now, one line, paragraph 8 of the division bench order 47, the order of demolition as directed here in above, that means in respect of
15th February 2025.
Shall cover item number 2.
2, yes, my lord. Now at page 44.
It has been covered in a contempt proceeding.
No, my lordship, both this entire order is challenging the writ court. 1 and 2 both is challenging the writ court. Lord, I could have understand, my lord.
Yes, what do you say, Mr. No,
Prashant.
Madam, you have to file a compliance report.
My lord.
My lord, I am the petitioner.
Today, if we injunct,
My
you
lord.
have to take this to the division bench.
My lord, we have to file a, my lord, if my lord sees the order passed in the contempt application, my lord, we need to file our compliance report. Already we are in contempt, my lord. So, my lord, if my lord sees the order passed.
Yes, you have to, Tahsildar appears to have proceeded with delay issued on 15 directing respondent to demolish.
My lord. My lord, page 47, my lord.
47.
In contempt, there is an order, my lord, that is staring at our face also. So what we can do, my lord? We have to file our compliance report.
এখানে ডিরেকশন দিয়ে দিয়েছে এটা হিয়ার রাইজ যেতে পারে নিজেও আগে ওটা বলে এখন এখানে ফাইন
Already demolition order is there, my lord.
কি দিছে order?
কিন্তু actually Tahsildar used the provision 202.
Yes, ma'am.
Tahsildar could have proceeded in terms of this order.
No, my lord. Due process of law means in terms of the local regulation. If I am occupying a government revenue land, 202 is the only provision to invoke for Tahsildar.
But if we stay the order, the division bench direction will stand frustrated.
Lord, may I say one thing? Again, at the cost of repetition. Lord, nowhere the division bench in the original appeal.
We understand. Now, last order which has been passed is it has not been complied. It comply with take police help and demolish. This is a division bench order. It is not a single bench order. But we could have stayed had there been a single bench observation.
I could have not. But the writ petition is a challenge to the eviction order. The entire order has been challenged. If not anything is done, my entire writ petition would go.
Tell us how do we avoid this? How can we say to the coordinate bench?
Does not lie with my mouth, my lord. Kindly appreciate. At best, my lordship.
It does not also. They are our coordinate bench.
Kindly appreciate one thing. What I pray, my lordship, for a limited purpose. For a limited purpose, on the first day of the circuit, 10th March, my entire writ can be disposed of.
Yes, what do you say, Mr. Prashant?
My lord, my first point is that, my lord, 7 November order was passed. the appellant has not challenged that order before the Honorable Apex Court. This is my first point.
7 November was consideration order.
Yeah, no, my lord, direction is there to demolish after due process of law. He has not challenged that order. He accepted that order.
Yes.
Number one. Number two, my lord, because of the contempt application, I moved before the Honorable Division Bench. The Division Bench directed to file a complaint. In complying that, my lord, Tahsildar preponed the hearing by giving notice to me as well as to the appellant. The appellant suppressed that notice and filed the writ petition before the Honorable Single Judge. And record was called for. After seeing the record, the Honorable Court come to the conclusion that notice was issued. Therefore, no stay was granted. My lord, suppression of material facts, my lord. One who approaches the Honorable Court with unclean hands. My lord, kindly consider this. Is not entitled to get any relief. Lord, I am showing, my lord, this is the 10th February notice I also received.
Sir, thing is the order has validity of the order of the Tahsildar, good, bad, indifferent has been challenged before a writ court. Writ
My
court
lord.
refused an injunction.
My lord, refused an injunction.
Injunction, he comes before us and says that the order which has been passed by the Tahsildar is not an order passed in due process of law. This is
No,
his,
it was followed, my lord.
sir, this is his contention.
Correct,
So,
my lord, correct.
This argument has to be considered by us.
My lord.
We negate such contention. Who can negate? In view of this urgency, we are being hauled up to decide the issue. Today,
my respect.
Today, if the demolition takes place on Tuesday, what harm will be created?
Lordship, kindly appreciate one thing, my lord.
On their part, they will have to say they cannot comply with that order now.
My lord, only to circumvent the order passed by the Honorable Division Bench, the writ petition was filed. This is my respectful submission, my lord.
Division Bench was to proceed in due process of law. He did not challenge the same.
My
So
lord.
he now says that the order has not been passed following the due process of law.
It was followed, my lord.
Assuming this is a submission which should not be accepted,
my lord,
who will decide acceptance? The regular division bench will decide.
The record was produced, my lord. The record was produced before the Honorable Single Bench, my lord. That is the reason I am saying. Only to frustrate the contempt proceedings, my lord. They filed the writ petition. My lord, he is an encroacher. He encroached government property.
Which is since the concern has been followed by the Tahsildar, demolition has been ordered.
My lord, suppression of material fact is also there. 10th February notice he has not filed.
This since the concern statute has been followed. Observationটা থেকে
উল্লেখ করছে statute মানে এই যে উনি যে এটা বলেছিলেন না যে ডিউ প্রসেস হলো এটা ওনার মানে ইন্ডিকেশন অর্ডারে যে প্রসেস অফ ল ইজ ফলোড
finding
statute has been followed.
You ought to have preferred appeal against this division bench order.
I was under the impression it's being due process of law. The Tahsildar would give a notice. Other provisions
Mr.
of law.
Jaipal, kindly come to page 46.
My lord.
46 last para. Tahsildar appears to have proceeded, albeit with delay, and issued an order of 15th February. directing the private respondent to demolish the unauthorized construction of his own. Now, very important, since the concerned statute has been followed by the Tehsildar and demolition has been ordered, failing which demolition shall be carried out. So, my lords have arrived at a finding that the Tehsildar has passed the order following due process of law. This observation, according to you, if we accept your submission, this observation is bad. But we cannot say that the coordinate bench has given a direction which, by this direction, your right to challenge the order has evaporated. Because due process of law, where can you argue? You will argue that before a division bench. When the division coordinate bench has accepted this finding, how can we protect you?
It's in the contempt, my lord knows the contempt jurisdiction, it's a limited jurisdiction, my lord knows. But contempt jurisdiction, a limited jurisdiction, my lord knows. If the order is complied with, my lord, by the Tahsildar, simply compliance would be placed to the Tahsildar by the court, before the court that order has been passed. Then the remedy lies to the aggrieved party to somewhere else.
To follow the due process. Order করলো কোর্ট তখন এখানে statute has been followed. Statute has been followed, but same statute that আছে 202 মানে 780 ওর একটা সুট ফাইল করা রাইট
আমরা তো তাহলে বলতে হবে that observation is
statute has been followed এটা
সেটা কন্টেম্পটে ওই অর্ডারটা পাস করতে পারে না, সেটা তো আমরা বলতে পারি। এটা তো কি ডিভিশন সুপ্রিম কোর্ট যেতে হবে। এখন আমরা যদি ওটা অবজার্ভ করি, কমপ্লাই করে, হ্যাঁ
পাস করছে ডিভিশন।
The prima facie, my lords, have a good case, my lord, in the writ petition.
বলতে পারি যে ওকে বলতে পারি তুমি ওই প্রবলেমটা দিয়ে রিপোর্ট ফাইল করতে এগুলিস তো করে দেবে,
কাল কি করবে?
How can we avoid this, no?
Contempt, you are not a party.
I'm not a party. No notice was did not kindly see the order.
You have no right of here audience because the contempt.
Absolutely, absolutely, absolutely. So only I have not put in notice. But it is staring in my face, my lord. Tahsildar passed the order. I've challenged in independent proceeding. I have a right to challenge, my lord. I'm not a remediless. Writ court division may never curtail my right to challenge the order of the Tahsildar. I've challenged it. Writ pending. No interim protection granted. So I'm before this court, my lord. Lord, I would pray for a limited period till the first day of the circuit. I'm residing there, my building is there, plan is there, I've obtained a plan.
When if we pass that order, can we tell the coordinate bench that we have passed this order, they have not committed any contempt, the coordinate, this Tehsildar will be in problem.
But Tahsildar order has to be, Lord, have to be tested. I've tested it, the order. But if I could show that the Tahsildar, while taking decision-making process, has went wrong, then Lordship, I am entitled to get an interim prayer, Lordship. Because the challenge in the writ petition is to the Tahsildar order, not of the division bench order. Are they in the original proceeding or in the contempt proceeding?
Pay for 7 days time. Demolition to বন্ধ করে
ডিভিশন বন্ধ করে দিলে কন্টেম্প খেয়ে যাবে। ফার্দার কন্টেম্প
যেহেতু এইটা হয়েছে,
requesting the regression bench to take note of this fact. Into a to part na contempt application.
রিকোয়েস্ট করতে পারি
এই অ্যাপিলটা কনসিডার করুন।
এই অ্যাপিলটা শুধু করতে পারি,
এই অ্যাপিলটাই তো কনসিডার করুন, নাহলে রাইট অফ হিয়ারিংস পাবে না। এই অ্যাপিলটা এবং ওই কন্টেম্প্ট একসঙ্গে যদি হিয়ারিং করে, if both the appeal and contempt application is are taken up together, then the issue can be considered as a whole.
But if any interim protection is granted by this court, I would appear before the contempt court. I will simply place the court, the order. Lord, kindly appreciate this thing. Lord, I have challenged the order of the Tahsildar. I have not been curtailed. My right has not been curtailed by the division bench. Lord, kindly consider that aspect. I have every right to have did so also, Lord, by filing a writ petition. So far as order of the Tahsildar is concerned, I'm on that, my Lord. I'm on that.
Contempt court হিসাবে
Contempt. Yeah, শুনবে, এই appeal-টা,
এই appeal-টার সাথে এই appeal-টা কি করে শুনবে? এটা তো ডিভিশন বেঞ্চ
ইস্যুটা অনুরোধ করবে অনুরোধ করবে যে টেকিং এনি ডিসিশন কন্টেন্ট ম্যাটার এটা
কি করে
টাইম তো এক্সটেন্ড করতে পারবে can extend the time. And I also should do use কতটা ঝামেলা। Now you give us some handle.
Lord, I am before this court, Lord.
No.
Lord, may I say one thing, my Lord?
Have you what is troubling us? Have you understood?
I could get it. No, I could
Basically,
I could
in
visualize it,
essence,
I could
or
visualize it.
effectively, you are seeking an order of stay of operation of an order passed to a coordinate.
But not my
In
point.
a contempt jurisdiction.
But my limited argument is when it's due process of law, when the Tahsildar have not acted, I have a right to challenge. I have challenged it. And the single judge have not. My point is that nowhere the division bench, in entertaining the original appeal, curtailed my right. Tahsildar has been directed to take decision in accordance with law.
We have entered into that aspect also, Mr. But because in the you come to the contempt order.
I have seen it, my Lord. I've seen the color of the order. I've seen it, my Lord. I've seen it, my Lord.
Some statute has been.
Lord, kindly, my Lord, I understand, my Lord.
And some submission is coming from us that 7th November order was passed. Demarcation, you are present.
These are the no, Lord. This is
opportunity of hearing was given.
No, not this matter.
So the only thing your right to institute a suit under 2000.
Lord, this matter need
202.
My Lord,
since Tahsildar has used the word 202.
Yes. So the due process law includes everything, my Lord. And not these legality of their submission, whether the report was given to me, whether I was the matter of a writ petition. Once they file the opposition, if they could show the writ court that I was present, I was given an adverse report beforehand, before passing, I was given a notice, I can understand. Ignoring this 2028 clause, my Lord, because that's a vital clause. It's a due process of law means in terms of this regulation, there can't be any other regulation, my Lord. That's my point.
Suit was also filed, my Lord. My respectful submission is that no suit was filed.
How can that be when the order was passed and when I have come to this court?
Is going to be it.
Not the
you show some material that we can act contrary to the coordinate bench order. This finding, how can we touch sitting in a coordinate?
The observation in an contempt, my Lord knows the limit role in a contempt proceeding. At best, the contempt, this does not lie with my mouth. Lordship, one thing has to be shown that the Tahsildar has not passed the order. But now, since there is an order passed by the Tahsildar, which I have challenged, and the same division bench.
We understand, but what same division? Same division bench has taken up
same bench.
Yes, same bench will take up.
Original order dated 7th November 2024 was passed by the honorable judges who have passed the order in contempt. Same judges.
Yes.
Not so those order needs to be read in not in isolation, my Lord. It has to be read in not in isolation. In that context, my Lordship, because Tahsildar did not pass the order within 45 days, not just some protection, my Lord. Till first day, my Lord.
কালকে সকালে 5 তারিখে কালকে তো come tomorrow it will be the
কালকে 5 তারিখ ও কালকে
tomorrow is the 5th.
Tomorrow is the last, because by the time the matter is taken up, the Tahsildar is would lordship because it would.
Miss Das is with us.
I understand lordship, but
And we are keeping at the first matter tomorrow.
as my lord, please.
And the first matter tomorrow, and Mr. Das till this decision is taken in this matter, don't take any interpretation. At 10:30 we will get the answer.
সেটা অর্ডার পাস অর্ডার পাস করি আচ্ছা লেখো কি সেটা তো বলতে ডিউ টু সিটি অফ
ঠিক আছে তাহলে
7th কি হবে 7th তো সেদিকে রাখতে হবে আর কি না আমরা বলতে ডিউ টু সিটি অফ কালকের জন্য রাখতে পারি সাত তারিখে তো কন্টেম্পটাই থাকবে due to paucity of time, the learned advocates appearing for the respective parties could not complete their arguments. In view thereof, leaves the matter for further consideration on 5 তারিখ লেখো the respondent number
3, my lord.
The respondent number 3 shall not take any coercive steps against the appellant till the matter is heard tomorrow.
I'm grateful. I'm deeply.
You show us anything, coordinate bench, otherwise we won't be able to help you. এটা ওনাকে দিয়ে
We have expressed our mind clearly, what is troubling her.
I understand.
One coordinate bench
Understand.
passed an order in contempt jurisdiction.
Understand.
Come adequately prepared on that.
I'll take the book.
Yes.
Yes.
Obliged.